I assume you were first to arrive for council people?
I think so, yes.
Yeah, okay. All right. We are hybrid today, which means we are both online and in person. So we'll begin with the reading of the preamble.
Thank you. Good morning. My name is Liz Kukla. I'm the Secretary of the Board of Zoning Appeals. I'm going to read the preamble for you this morning, this Monday, November 4th, 2024. In compliance with notification requirements of the city's open meeting law and section 101.021 of the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the city planning department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Please note that call-in users can unmute by using *6. All meeting activities being recorded via the WebEx platform. These proceedings are also being live streamed via YouTube for public view. We've provided a link to the meetings for those who wish to speak on a particular case via our website and email. All requests to speak on a particular matter have been considered. We have also received emails from those who have provided written comment on a particular matter. Back to you, Madam Chair.
I'm going to officially call us to order, even though we got started. Okay, we'll call the roll, please.
Sure. Ms. Roca.
Present.
Ms. Wilson. Present. Mr. Madison.
Present.
Ms. Holzer is online this morning.
Great.
Thank you. Ms. Day.
Same here.
Madam Chair, we have a full quorum.
Excellent. All right.
We do have one postponement this morning.
All right, let's go over that.
Calendar number 24-172 at 2033 Clover Avenue. Clover Court Ltd. proposes to construct 24 apartment units in a B1 two-family residential district. The councilwoman is requesting a postponement at this time.
Okay, request by council.
And if we could just confirm or request that the appellant, if he is online, let us know.
All right. Do we have an appellant present for 24-172?
Thank you, Madam Chair. We did send some.
Yes, we do.
Okay, excellent. And you understand that the council person has requested a postponement?
I understand.
Okay, excellent.
I have a question on that. We actually didn't know about the postponement. Next steps, we just reach back out to the councilwoman and then bring this back.
Yes.
Yes, yes.
Okay,
Exactly.
thank you.
There likely will be a need for you to connect with council, perhaps your CDC, your Community Development Corporation, and they may see a need for you to have a public engagement meeting, but that will be up to them, and I suspect that may be why they requested the postponement.
And also, Madam Chair, they need to be reviewed by City Planning Commission.
Okay,
And we do have an email address that we did try to reach out with the applicants. So I believe they have my contact information. If they could send me a better or a different email address, that would be fantastic.
okay. And I don't know if you heard that, but you need to be reviewed by City Planning as well.
Okay, thank you.
Okay, if you'll kindly send your best email to Ms. Kukla, you can send that through the chat. We'll pick a date for them.
Sure, Madam Chair, 30 days approximately would be December 9th,
Let's push it out a smidge.
December 16th, and yeah, December 16th. We'll be
Okay.
in state into summer.
Okay. Calendar number 24-172 is postponed to December 16th. A postponement at the request of the council. Okay, anything else?
And it's all that we have this morning for withdrawal and such.
Okay, all right. Let's do introductions. Ms. Leonard, since you're here in person with us today, we'll start with you.
Shannon Leonard, Chief Zoning Administrator.
Okay.
Mary Cornelia, City Law Department.
Ms. Kukla.
Kukla, Secretary of the Board of Zoning.
Okay, Mr. Bay.
Hello, my name is Xavier Bay. I'm representing city planning.
Okay, our court reporter is online today. We have 2 microphones here at the table, so when your case is called and you step forward, please be sure to speak into the microphones. And that goes for anyone online. You need to be clear with your speech. And Mr. Madison will go over our rules of order. This is essentially, if you were on a plane, this would be your in-flight instructions. So listen up and don't play with your phones. All right.
Thank you. Again, thank you all for being here. The order of the hearing for today is that the description of the case will be read into the record. Anyone wishing to speak on the matter will be sworn in. A history of the property will be read into the record, followed by the legal standard, as well as information provided by the project team to present on their proposal. Following that, board members will have the opportunity to ask questions. Those in favor of the project will have the opportunity to speak. Those in opposition of the project will also have the opportunity to speak. The secretary will read any written correspondence, followed by the City Planning Commission to give their recommendations. And then from there, any council members present will have the opportunity to provide comments. The project team may respond at that time, made by any comments by any of the parties involved. And then board members will get the opportunity to ask additional questions. Following that, a motion will be made and seconded, and the secretary will call for the roll call. Rules of today's hearing, again, continue to speak clearly for the record. Reporter to record information. Do not speak unless recognized by the chair. All conversations must go through the chair. This isn't a back and forth conference, we should say, but any questions need to be directed to the chair. Hold your comments until the speaker is done speaking, and then following that, at the request of the chair, if any time during the duration of the engagement, we may request 2 minutes to limit conversation. Back to the
Super.
chair.
We have given Mr. Madison that task since he has pretty extensive knowledge and experience in Robert's Rules of Order. And so he is our sentry now. So we welcome him. He is our newest and 5th member of the board. We have council present. So I'll ask you to step to the table. I believe, Ms. Kukla, we want to start with 21-108. Is that correct?
Yes.
You got it. All right. All persons present for calendar number 21-108 in the room, please step forward. Join us at the table. If you need to, you may have to roll a chair up and go onto the wings of the table.
All right, my apologies. It took me a second. 21-108 at 6806 Harvard.
That is correct, sir. Are you
Okay.
here for this case?
Yes.
All right, super. All right. We'll go to Ms. Wilson.
Where's Kurt?
Oh, Ms. Holzer, yes, I forgot. Ms. Holzer is with us virtually. And so she's back with us after being gone a couple weeks. So she's resuming her role as reading the cases.
I am here. I missed everyone. So, all right.
Missed you.
Our first case is calendar number 21-108. This is at 6806 Harvard Avenue. TMS Enterprises owner proposes to change the use from a multifamily dwelling to a used car lot in a D2 multifamily residential district. This matter was originally heard by the Board of Zoning Appeals on July 26, 2021. The board denied the requested variances. The Common Pleas Court affirmed the board's decision. The 8th District Court of Appeals reversed the Common Pleas Court's decision, and they remanded the matter to the board. In its journal entry dated May 16, 2023, the 8th District Journal entry states, "We reverse the Common Pleas Common Pleas Court's decision and remand the case to the BZA. On remand, the BZA shall consider TMS's change of use application in light of its vested right to use the property under the property's prior general retail zoning classification. We further note that despite assertion to the contrary, CCO 343.11, which governs general retail districts, does not provide any restriction prohibiting the operation of motor vehicle sales facilities within 100 feet of a residential district. If the board finds that a used car lot should be permitted in this district, the board must then also consider the following sections of the Cleveland Codified Ordinances regarding area variances, and that's section 349.07A and 349.04F, which are both listed on the screen. I'll also note that city planning requested postponement of this case from September 30th, 2024 to allow time for further review. The appellants then requested a second postponement from October 21st due to a scheduling conflict. No testimony was taken at that time. And with that, I will hand it over to Ms. Wilson for the oath.
There we go.
Thank you, Ms. Hauser. I'll go ahead and swear in everyone who's present for this case. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth? You raise your right hand, reply with I do, state your name, spell your name, and give your address, and I'll start with you.
I do. Tony Brancatelli, BRANCATELLI, 6924 Ottawa, Cleveland, Ohio, 44105.
Okay, thank you.
I do. Kurt Weaver, KURT, ADER, 2008 Valentine Avenue.
Okay, thank you.
You too.
Naveed Hussain, Commissioner of Construction Permitting, Building and Housing.
Okay,
You
and
spell your name.
Yeah, N for Nancy, A for Apple, V for Victor, I for India, D for David. Last name Hussain, HUSS, A as an apple, I-N.
Thank you so much. Councilwoman Rebecca Moore, I do. Rebecca, REBECCA, Moorer, M as in Martha, AURER. Thank you.
Caitlin Flannery, Project Coordinator of Construction Permitting, Building and Housing. It's CAITLIN FLANNERY.
Okay, your role again, please.
Project Coordinator, Construction Permitting.
Are you here for this case?
I am here for this case. My name is Carolyn Downey. I'm an attorney with the city of Cleveland. I handled the initial appeal that this case is based upon, and I'm here only if there's some questions that might come up as to the appeal.
Okay,
Super.
that sounds good. Should we have her swear in?
Yeah, just, we'll swear you in, just.
As an attorney?
Yeah,
She doesn't know. Okay,
Yeah.
we'll not swear you in.
Okay,
Yeah.
I'm just curious.
Thank you so much.
All right, thank you.
Sometimes attorneys choose to or
I
not,
know.
so,
I bet she's every week.
yeah. Yeah. It's court TV here. All right, we'll go online.
All right, is there anyone online wishing to speak in this matter?
Thomas Sullivan. I'm the owner of TMS Enterprises, 6806 Harvard.
Okay.
And I'm Dan Linder, his attorney. I'm the attorney who handled the appeal too successfully. Thank you.
Okay, I'll go back to you, Thomas. Can you state that you will give the testimony that is the whole truth and nothing but the truth?
I will.
Okay, thank you so much. And did I hear you spell your name?
SULLIVAN.
Okay, perfect. Thank you so much.
And we got the first name, Thomas. Okay, great.
Yes.
Is there anyone else online wishing to speak in this matter? All right, hearing none, back to you, Madam Chair.
Super. Okay, we'll take history of the property.
Thank you, Madam Chair. You will hear a lot of testimony about the zoning. So I'll give you the basics that was read in the original hearing. The property was originally zoned general retail in 1929. In November 6, 2020, the property was changed, or the address was changed to multifamily. In our Records Administration Office, we found that in 1908, a one-story milk house was erected. 1891, and this is for 6812, which is part of the project area. In 1891, a permit was issued to erect a two-story new dwelling. And in 1906, for that particular address, a permit was issued to erect a two-story barn. There were no variances on file at that time. And Madam Chair, I believe that's where I will stop. There is, again, more testimony that will be given from the opponents.
Give us that year again that went for multi-housing.
November 6, 2020. Is that right? I think that's right.
So zoning change became effective, that's correct. So, but the rezoning had started prior to that date.
Okay.
I have the maps, if you want. It's the original maps.
Do you want to see the maps? Okay. Do you have enough to disperse them?
I have one set, it's the three phases.
Okay, so we'll look at them and pass them down, I guess. Start with Ms. Roca and she can, we'll pass them down to Ms. Roca, let her review and then they can come us back. Okay, legal standard?
Well, Madam Chair, members of the board, appellant was denied a use variance from the regulations of the zoning code on July 26, 2021. Appellant appealed to the Cuyahoga County Court of Common Pleas, which affirmed this board's decision. Appellant appealed to the 8th District Court of Appeals, which reversed the trial court's decision and remanded the case to this board to, quote, consider TMS's change of use application in light of its vested right to use the property under the property's prior general retail zoning classification. Unquote.
Okay, super. Thank you. All right. Mr. Weaver, I take it you're the architect for the case?
Yes.
Okay. Are you going to be the spokesperson?
No, I believe Dan will be the spokesperson.
Okay, all right. So here's what we'll do. The project team is going to do their presentation. You're going to tell us what's going on, what's happened since we've last seen you. As it happens, I am the only person that was on the board at the time your case was first heard. Everyone else is new. So you're going to have to really bring everyone up to date on what's been going on. Okay?
Certainly.
And so we'll hear the project team and then we'll go and hear from the various people that are sworn in to make statements. Councilwoman, typically council likes to speak last. Is that your option here?
Yes.
Okay, great. Okay. All right, we'll go ahead with Mr. Linder. You're going to be the spokesperson.
Yeah, I'm just gonna quarterback this. I'm gonna let the witnesses do the testifying, but I will keep it organized, if you will.
Okay, go ahead.
All right, so last time my client was before you, I was not the attorney. I was on the call, though. I actually saw it. And at that time, the former council person who's there in the room with you had we had a change of use application already pending, and they changed the zoning to residential. Through the appeal process, they've held that we were vested with the right of general retail, which of course, used car lot is a permitted use. And I know Kurt has put together plans that meet with code specifications under that general retail use that we are vested with. I know that despite the rezoning of this area into residential, there's been no development of any of the surrounding lots. The property sits pretty much stasis, but what did change about our property is very recently, within the last couple months, the city came in and decided to bulldoze one of our standing buildings. My client has sunk $100,000 into this property, trying to make improvements to get this thing ready. And then perfectly viable building that was recently bulldozed. So there's still litigation underway regarding eminent domain resulting from the city. We believe it's a taking of what has occurred. Having said that, we are trying to proceed forward with the development. And so Kurt, at this point, I'm going to have you present what you have put together regarding this property and the plans and how they conform with the city code.
Madam Chair, members of the board, Kurt Weaver, architect, good morning. The drawing sketches that were on the monitor, there were 3 images, 2, and then 1 that's shown now. So 1, 2, 3. That third image is reflected in this SD31 drawing, which was the latest iteration of the revision to the drawings. It's dated 7 June 2021 in response to comments and criteria that were coming forward relative to the project. So I think that part of our documentation in terms of the variances and such speaks to striping of the lot for guest parking spaces and a ratio of 25% of those guest spaces to the total lot. So we are in conformance with both of those criteria with this plan. The plan, as Dan stated, did include the restoration of the former milk house, which has been removed. So part of my question is, what is the impact of that removal, albeit not of our doing? And if we're to put the building back in place where it was, there's gonna be other variances or things that might come up, and how do we manage that?
Okay,
If there's any other questions, I'm happy to answer any questions.
and I believe all of this, all the drawings were in the packet, right?
Yes, they.
So has everyone had an opportunity to review those? Okay, we're good then.
So I did review the drawings, but of course I'm not an architect, so can you talk us through like what you have, what you intend to do, all these details?
So I'm looking at the one that's on the monitor, and I'm gonna speak from that because to my recollection, and mind you, I did update myself, but it's not as fresh in my brain as it was at the time when we were working on it. But we increased the green space on the site, which you can see by the green swatch that wraps around the project. The front has there's an existing curb cut that we utilize to come into the property and do the ornamental fence and the landscaping berm and such like that. It's a used car lot, so you can see we have cars dispersed throughout the lot around the perimeter and as much as we can. And then I think it's 7 guest parking spaces. There's a catch basin in the center of the lot to accommodate drainage. And then the black square was the former milk house that's been removed.
Are you following that?
I am.
I believe there was some portion of board-on-board fence around the exterior perimeter. And I don't recall what the intent was to extend that and completely encapsulate that perimeter with the board-on-board fence.
Is there an office structure in there somewhere?
The black square, black rectangle on that lower right-hand corner was the former milk house that was to be restored as the operations center for the property.
Okay, and that's gone now, right?
I believe so. I think I just saw in that photograph that was up on the initial photograph of the site that, yeah, it's been removed.
Do we have a laser pointer? Okay,
We do not.
okay. Let me point this out. So here's your drain,
Correct,
and this is the grading to the drain,
correct.
okay? These.
Yes,
1, 2, 3, 4, 5, 6, 7 are your
yes,
guest parking places.
correct.
These around here are your,
Correct. I think there's 20.
okay. You can't, the image is too pixelated to read the numbers, but that looks probably about right. So those are your, and then this was the milk house, your green space, and your planting material here.
Correct.
No planting material on the rest of the perimeter?
I think we have landscaping across the front. That the building adjacent to us to the bottom of the page
Here,
is a 2-story building, so it's gonna heavily shade that other swatch of green right there, so I
Right here.
didn't show any trees or anything along there.
okay.
And then at some
Oriented,
measure, we
so
want
the-
some
Sorry,
visibility.
we're oriented, so this is north, right?
No, north is actually.
North is
yeah,
that way,
correct.
so you did your drawing on the side. You.
Yeah, my north there is on the bottom,
Okay,
but yes,
all right, so
north
your
is
north
facing
your north is really,
to the left.
yeah, your north is left rather than top, okay. All right, so this is west, that's east, this is a 2-story building.
Yes.
What's over here?
It's a resident, it's a forward, I think is a house, and that's where you are there
Here?
is, like, that's another house, that's a house. Garage,
To this house
no. Garage to the house down the page,
down here.
yes,
Okay, so this is one lot.
yes,
This?
vacant lot. That's the two-story
Two-story
building.
building. Okay,
Excuse me, Madam Chair, I do have an aerial view if you prefer.
super. Let's go to that. I think we've walked through this, so everyone has a good orientation. So,
Madam Chair, just to reiterate,
Yeah.
the parking spaces are striped. I heard you testify to that.
I thought I saw language in there that said not to stripe the guest parking spaces.
language from what?
3409, Madam Chair.
Mhm.
Asphalt or other surfing materials, customer parking are not striped.
Okay.
Doesn't make any sense
Ms.
to me,
Leonard,
but
Ms. Leonard will chime in on that.
Yeah, so to qualify, first of all, at the last hearing that they had prior to going through the court system, they submitted a fully compliant in terms of the area variances, site plan that's in the record. So they don't need any variances except for the use variance if you decide to look at this as it was originally adjudicated under multifamily. So that's the only difference. They don't need one and they don't need two. They just need the use variance if you decide to review this under multifamily instead of the general retail prior to the original change of use permit.
Right, okay.
Application.
All
So
right.
that's a determination for you all to
Okay.
make.
Do you want to clarify for Mr. Weaver the striping issue?
Yes, striping is required. So
Okay.
when we looked at this case, when it came before us, we didn't reissue any letter of nonconformance. We kept the same one. But that's because that by the time they had come through in the previous hearing, that they were going to become completely site compliant. So as long as they are maintaining that original, most revised site plan that we have in possession, then they are fully site compliant. It's just the use of a auto sales and a multifamily, if you choose to review it under multifamily, rather than the general retail from their application that the court says that they put in. And then there's information regarding that in your packets.
Right, okay. So you would need to stripe that based on what Ms. Leonard just said. And typically what we ask is also for tire pumpers. That's not an issue before us, but that's just something we typically request in these situations. Just as an FYI. Anything else, Ms. Roca? Not at this time. Okay, great. All right, go ahead, Mr. Weaver.
Madam Chair, just in anticipation, if we were to gain an approval, I think it's our intention to try to put the structure back where it had been. So we would need a variance for the setback on that structure.
I'm not familiar with the demolition of whatever structure he's talking about. Are you talking
Okay.
about the former milk house?
Yes.
I'm not familiar with the demolition of it, but
Okay, we may
if
get
you
more.
change your site plan, we would have to re-adjudicate. Yes.
Okay, does that make it clear? So if you change your site plan, we'd have to re-adjudicate.
Madam Chair.
Yes.
Just a question.
Yes, go ahead.
Their site plan wouldn't be changing, there was a building removed, they would be putting the building in the same place. So it was adjudicated with the building on it. So it's not really a
Right.
change in site plan.
It's new construction of a new building, though.
In the footprint of the old.
That would be a new permit.
Irrespective of how, excuse me, Madam Chair,
Correct.
irrespective of how it got here, it would still go back through building and housing, and they would tag it as new construction,
Yes, we would have to.
right?
Right.
So then we would be back here to ask for a variance to
Right.
encroach on the side yard setback.
Right.
And anything else that they might
Well-
find, because we didn't look at it that way when it went through review the first time.
So the new building, you're saying you would put in a new building at the same site for like a retail office type building?
Yeah, it was the office for the operation.
I will
You know,
like to
included a
tell you whether
restroom,
we need a new
those kinds
permit.
of things.
The commissioner of construction and permitting is sitting here, so he could tell you if they would need a new building.
Okay, Right.
application.
All right,
Yes, we would issue a new building permit application.
Okay.
It has to be submitted for us, and then we will route it to zoning, we'll look at it. If there are any zoning requirements based on the basement of that, then they will decide if we should be required.
okay. And for the court reporter, Mr. Hussein, if you could just state your name.
My name is Naveen Hussain, I'm the Commissioner of Construction Information.
Super, thank you. Okay. Does that clarify questions for you, Mr. Weaver?
It does, thank you.
Okay, was that an excavated building, the milk house? Did it have a basement?
It was a slab on grade
It
building.
was a slab on grade. Is your intent to do another slab on grade?
I
And would you maintain the same footprint?
Yes.
Okay, all right.
All right, just one question, I just want to clarify.
Yes.
Given that the original plans that came through had the milk house on them, the milk house was then demolished through the city demolition bureau. Are we saying that the site plans as they have previously been submitted can be considered in whole today by BZA? Or that if we get to that point, or are we saying that he's going to need to resubmit the plans with the new building included?
He's going to need to resubmit the plans with the new building included. So anytime you have a demolition, you get rid of a non-conforming use. And to rebuild, you would need a new permit. So there would be a new adjudication period. So it is possible or likely that if they place it in the same location without the proper setbacks, they would need to get a variance from the Board of Zoning Appeals.
So with that in mind, I want to make sure that the applicant feels that we're all on the same page that this is sort of essentially right, like what you would consider ready for review, because essentially these are now outdated plans.
Correct.
And that would be my question
Right.
is, are we even hearing the right thing at this point? Because
Right.
we don't have plans with a proper building on it.
Right.
As well as the variances that are requested seem to not even be needed. So I don't know if we're hearing the right thing here today.
So if we unpack this, it opens up new situation, given the fact that that building is no longer with us.
Yeah, so today we're hearing the remand from the Eighth Circuit Court of Appeals, but you're
Right.
correct, the site plan, now finding out that that building's not there, is news for myself. So in terms of the site plan, if the site plan is gonna change, then obviously they'll have to come back for the area variances, but it was remanded here to be heard, based on their findings.
So
and
we have
for
to-
y'all to make a determination whether to review it under the multifamily or the general
So what
retail.
we would be doing today is making a determination on the change of use only. And then they would have to resubmit for a new permit from the new building with new site plan, and then they would potentially be back again a second time to ask for variances for setbacks potentially.
Correct?
Yes.
Yes.
So do you, I guess this is a question, maybe Madam Chair, that we should ask the appellants and then their attorney. Do they want to bifurcate this, or do they want to resubmit everything? So they're here, they're here today, I guess, so I guess it's up to them, but.
Right. Okay, so it sounds like,
Madam Chair, if they
Yes.
resubmit, they will be judged under multifamily because that's a non-conforming.
Okay, so that's.
What you're hearing today is determining with the Eighth Circuit to look at this.
So
either
they have
under
no
general
choice based
retail or
on what you just
multifamily.
said. Yeah, okay, I understand.
Okay, so we've been instructed to look at this under general retail. Right?
Yes.
And so given that we're looking at this under general retail, it seems to me.
There's
that
no
there's a
variances needed
decision
under,
we need to make.
if you're looking at it under general retail, there is no variances required. But if they're going to resubmit a new site plan or the used car lot, they will be judged under the current zoning.
Okay, so we have a remand from the court to consider under general retail, so that's what we're here doing today.
Correct. So are you clear?
I'm
Ms.
clear
Wilson,
on
are
the
you good?
procedural.
You also
process.
made a determination to look at it under general retail or listen to the testimony.
But if it's general retail, do we need a variance? If
You
we're
don't.
just- Right. So
There's
what
no
do we need?
variances needed based on this site plan. If you're looking at it as because a used car lot is permitted and there was an error on the original non-conformance of within 100 feet. I think, so it's up to you all. whether, the city of Cleveland originally adjudicated under the zoning at the time. The Eighth Circuit is directing it back at general retail.
Right, so we don't, there's no variance being requested because there's not one needed, if I'm understanding this correctly, so there's nothing for us to hear at this point.
Right.
But again, that's, and
All right.
I think that there was a lot of confusion around the permits that came through, so.
Okay. All right.
The
state
court
clears that up.
The court said that they were vested from a permit that was actually a demolition permit. So that's
No,
where the real.
it was a change of use permit. There were 2 change of use permits submitted.
Okay, sir.
That's not for,
Sir, I'm sorry to interrupt you, but you need to state your name before you make your statement and go through the chair.
yeah, I'm sorry. This is Attorney Dan Linder. I'm the one who handled the appeal and
Yep.
all the attempts to get that remanded, which were denied. And ultimately, the court specifically ruled that that there were change of use applications in, and that we were vested with the general retail zoning. There's no possibility of it being viewed any other way right now.
Okay.
That's my understanding from the court's opinion as well, so.
So, I mean, it's up to.
I thought the planning was presenting a separate opinion than that, and I don't hear anyone presenting that.
Xavier's here to present.
So I'm the planner for the area now.
All right, we need to come to the table, please, and we need to swear you in.
Let's stay over here.
Okay.
Probably you pull the chair, Kenya.
Safe method from city planning.
All right, do you swear or affirm that the testimony you're about to give is the whole truth?
Yes.
Raise your right hand, reply without any state your name, spell your name.
Okay, my name is Kenya Gray, KENYA GRAY. I'm Southeast City Planner in the City of Cleveland, Planning Department. Is that good?
Yes, and just affirm.
I affirm, I'm tell the truth. I do, okay.
Yes.
So, so from the planning department, like our position is to stand by the 3 rezonings, and that multifamily is in alignment with the future citywide plan. And basically like the existing nature of the area is very residential currently. So putting this general retail used car lot here, like I'm not sure how that fits within the context of the community. And that's the stance that the planning department is taking.
Okay, thank you, Mr. Gray. Thanks for being here in person with us. Have we lost Ms. Kukla?
She just need to step out for a moment.
Okay. Mr. Brancatelli, did you want to make a statement? I think you might shed some light on this perhaps.
You want my intro remarks or just?
Go ahead.
Okay, I will give you my intro remarks then.
You might just refresh, since we have new board members,
Yes.
what your role used to be and why you're here for us.
Okay, well, I'll be,
Since not everyone knows you.
I'll be brief because I heard a 2-minute warning from Nina that I'll be cut off, so.
Pass this down.
Real quickly, I'm Tony Francatelli. I was the CDC director of South Coast Development for 17 years. And then in 2005 became the councilperson of Ward 12 for 17 years, and now am retired and enjoying vacations when I can, and 75 Indians ball games, or Guardians ball games this past great summer. I'll just run through these really quickly. I had a number of notes. One, I want to recognize the planning department. We had been doing rezoning for a number of years, and there's been what was stated earlier, the Harvard corridor from 77 all the way to Broadway was broken up into segments. In 2019 through 2020, city planning department was instrumental in leading the charge to the community. These were the last few phases of over 20 pieces of legislation that we worked, the department, like a rented mill, for years to go ahead and rezone what was a very historic neighborhood. And we were doing this through the lens of the comprehensive plan Connecting Cleveland 2020. And this was a continuation of zoning that we've been doing in the Broadway Slavic Village SPA for years. Jenna purchased a residential home on 2/10/2020 through sheriff sale. And we were going through a planning process and community engagement. We've heard, the planning department was incredibly gracious in their time and coming out to community meetings, coming out to public meetings, and then working with local businesses as we were making all these changes, throughout the entire Broadway Village SPA. On October 7th, 2020, City Council enacted ordinance 760/2020 that changed the zoning classification from general retail C2 to multifamily district D2. On October 28th, TMS applied for a permit to demolish an existing residential home at 6806 Harvard. I have a significant amount of experience since the board, most board members are new. I was born and raised in the Broadway South Village neighborhood. I know this Harvard district quite well. My family home was on Harvard for years. I went to Harvard Elementary School, which is 2 doors down from this. My dad owned the Shanty Inn Bar down on Harvard for many years. And my first job in 1973 with a paycheck was digging graves at Harvard Grove Cemetery through what is now known as the Summer Youth Program. I was a young kid and we were working in an old historic public cemetery. So 6806 Harvard, I included the second page in was a property description. The photos that you see there are photos that I took this morning that show that location of the vacant lot in respect to the building just west of it, 6802 Harvard, which is a commercial building under renovation, a 2-story building. 68 to the left of that is 6820 Harvard, which was a new construction home years ago. The family that bought it, I think, was nearly a $200,000 property. Next to that was Harvard Village Senior Center, which was my elementary school and now a senior center. And behind it at 6813 Colonial is currently a house that's under renovation. The significant point of this photo also is you can see the 2 guardrails that have been there for a long time. This is a very heavily traveled street. There has been a number of accidents on that street and around this curve. It's at a bend, which is why these guardrails are there. I approach this also with the issue that the residents have expressed was it's a safety issue. Is putting a car lot here, moving cars in and out, having this kind of additional traffic is a significant change from having a single family residential home. The second photo on here is in fact the lot today as it stands. And you can see the house in the background of Pony that's under construction. Jumping into what 6806 Harvard was. It was a single family home, 4 bedrooms, 1 bath, approximately 1,600 square feet. And there's 2 photos of what that house looked like in August of 2014. We'll move on from there.
Mr. Beck, Mr. Beck, do you have the pictures of the house?
I do not have those photos in the presentation.
Okay, all right, thank you. Go ahead.
And then just as a note, when we're talking about the process and what occurred when, I just wanted to footnote what's in the city public record, 6806 Harvard, a violation was issued in May 19th of 2020. When the house was demolished with no permit. This is significant because when we talk about working with the planning department, going out, working with residents, doing public notice, when zoning changes happen, the planning department sends out notices to the impacted users. So those notices went out, or the property owners were noticed, and this property mysteriously was demolished in May of 2020 with no permits. Demolition with no permits is a significant issue. If anyone wants to speak on it, but I can tell you having full demolition permits, you have to get sewer district, water department, asbestos clearance. These are all processes that are significant when you're demolishing any structure. Right? All these things come into play when you demolish a structure. When you show up in the middle of the night and demolish a structure with no permits, it creates a problem, which is why the violation notice was issued. So I included the violation notice. And then further, as time continued, 6806 Harvard. And note, November 2020, what's included is a couple photos and the notice from the city of Cleveland that a complaint was turned in that plumbing work was being done with no permits. And a violation notice was issued. The violation notice and the complaint are attached. And you can see the work that was being done and the open pit that was done. And you can see the plumbing work that was there to start the process of putting in a parking lot, which some could be considered. So then another complaint was turned in December, 6806 Harvard with an open pit. And you can see the pictures, that this is a heavily traveled, this is say across the school area. And that open pit stood there when that property was demolished in May. We're now in December, this pit was still open, and creating a huge hazard. I know the hazard firsthand because back in 1975, I might have been driving my sister's Satellite and got T-boned from a property coming out of Ottawa that directly impacts this pit. My sister didn't talk to me for a week, but that's okay. That was a bonus when you're a teenager. At 6806 Harvard, demo permit was pulled October 28th, 2020, many months after the house was demolished. So that raises a big concern. And the demo permit was not closed until January of 2021. That's a long process to have an open pit. That's a long process to have these kind of concerns and creating that kind of hazard. The other question on this is the permit pull was to raise the building and the garage. And if you go back a picture, you can the euphemism of calling that a melt house, that was a garage. And that was always that garage was an accessory use. So when you look at the picture with the open pit and the sewers, plumbing work that was going, that's a garage back there. That's not some special historic prevalent building.
Okay.
And that's why that building was demolished, because you cannot have an accessory use that stands alone.
Okay.
No, I'm sorry.
Yeah.
Oh, I see.
Yeah.
Okay, got it.
Ms. Roca?
So that was the driveway going to the garage. That was the garage. So the concerns about having, and that original plan was to demolish the house and garage according to the permit. So that lasted for quite a while. And in testimony in 2021, the defendant said that his whole goal here in the beginning was just to build something that would beautify the area. And he noted that he was a residential home builder in his testimony. And as a residential home builder, if anybody's involved in these activities, they know permits are required, but permits are not full. So they knew their responsibilities. They didn't take it. What I included in here is also just a concern that you're raising the question around beautifying the neighborhood. TMS Enterprises, which owns this property, also owns 7309 and 7407 Union. Those were also under contention and violation notice of issue. And those violations were included here, and the site plan was included here. And then here's a couple of pictures of what this defendant is claiming beauty. And I'm not sure what beauty contest from how I inherited in Slavic Village, but these are not beautiful car lots. These are pretty horrific car lots that are now under violations. And I don't want to win that beauty contest from hell. Nor do I want him to be the beauty queen judging, because we see what happens when somebody judges beauty contest. Once they grab them by their, whatever the key word here is pistons. It's a used car lot. They're grabbing them by the pistons, and this is what we're dealing with in our community. When the court hearing occurred and they ruled in our favor that the Board of Zoning was in their right, we thought that was the end of this responsibility. When we talked about impact, when we talked about a defendant who says, one of the things we talked about on these boards is what financial impact this has on folks. The financial impact is on the neighborhood. When you put a used car lot next to a brand new home, when you put it next to a multi-family building for millions of dollars for senior housing, it's walking distance, you have commercial properties getting renovated. These are the impacts that it has on our community. So I understand that we bought this property at a sheriff's sale. We bought a house at the sheriff's sale with current use was residential. When the zoning changes were coming through, the property got demolished without a permit. The court was right, the second court was right. He had the right to do the right thing, but he did not. And the filings were all after all the changes were being introduced and being voted on. And so the concern that we are now hearing this again, we have a new mayor, a new council person, I don't know that they anticipated that the council person would get a Stanford law degree that can review these. And I support the councilwoman's public statement that she sent out to our residents that this makes sense not to have this as a parking lot. And supports the community's opposition to this. Looking at what has occurred and looking at what we're facing, this board has a right to uphold the decision. The law department has a right to appeal the second decision when they wanted us to hear it again. We're hearing it again. And the city had a right to demolish the accessory garage. So we can go forward and look at how do we, and the original plans that I got from Mr. River showed that garage on there, despite the fact that demolition permit said that was going to be demolished. These are all concerns that raised that the right thing is not being done. The residents have sent, and you guys heard testimony last time, almost all the neighbors around the area.
Madam Chair, just wanted to.
Yeah.
The 2 minute, just.
Okay.
Yeah.
Okay, thank you.
I've extended a little grace to you, given your previous,
So,
your role.
So I appreciate the time and I appreciate the support to look at how we make the right decisions. Thank you.
Okay, super.
Madam
Okay.
Chairperson, the order somehow has changed that the property owner hasn't gotten to make his presentation. And Mr. Brancatelli jumped ship here and jumped the line here, but I'll point out, everything he said has been judicially declared the opposite. Finally and judicially declared that everything he just told you isn't true. Now, separately, the property owner has an opportunity to also speak about his property. And I don't know how Mr. Brancatelli was able to filibuster his way ahead here, but I'm glad he did because it highlights just how contentious he has been when he was a council person and how inaccurate he was. For example, he keeps referring to a garage. That garage had full plumbing and sewer. That was not a garage. It was a separate standalone building that had a full function. And so, again, the 8th District Court of Appeals has fully and finally adjudicated all these decisions that he brought before you. And in case you're questioning the order of the permits here, you'll note that this all went down during the height of COVID during the shutdown and City Hall was shut down. Permits were pulled at the first availability. But separate from that, permits were pulled, and again, the 8th District has already decided this. So everything he said isn't even open for consideration. It's moot. So now the property owner should have an opportunity to speak about his own property.
Okay, absolutely. Your architect did his presentation, and I apologize if we didn't let you complete your presentation. I thought that was the extent of it. So go ahead and the rest of the project team can speak.
Hello, Thomas Sullivan. You know, it's interesting, Mr. Brancatelli, his tone of his voice and his demeanor. You know, in 2007, he brought up 7407 Union. In 2007, I was the only car dealership owner that did a storefront renovation with him that cost over $20,000 when all dealers were asked to comply with that, which I did do. And then at the end, he did not grant me my permit. That's first thing right there. That's if we, you know, Mr. Brancatelli just brought up that a completely made a false statement. The man lives across the street on Ottawa Avenue as he gave his address. The house, he conveniently showed a picture of 2014 of the house. When I bought the house is not a 4-bedroom, 1-bath structure. It was a gutted structure with boarded up windows. The garage that he's questioning that was raised and trying to insinuate it's point blank lying saying was the milk house was the 2-car garage on the east side of the house. That the pad is still back there. Okay. I would also like you to, the board, to look at the picture that he provided with his, that he quoted as illegal plumbing. Can you please look at that picture?
It might not go up on the screen.
I don't need to see it if you just are looking at it.
Yep, it's in the packet.
Okay. You see the sewer coming from the street, traveling back through the basement hole.
Correct,
And then you'll see a green pipe that it was referring to.
correct.
Okay, that green pipe was just a mark where the sewer was. Him and his henchmen conveniently cited me for using that. Do you see where that sewer continues past that point to the back of the hole?
Yes, go ahead.
Okay, that building, that milk house was built in 1890s before cars were produced. There was not a garage built back there. Structures built back then were barns to provide horses, which there was a horse track right across the street at that time. There was no sewer. No sewer would have been put in a structure unless it was a livable structure. That, if you look at the pictures of that, there was a complete sandstone building with 2 windows and a side entry doorway. Okay, the original front of the building is why Mr. Brancatelli is trying to refer to this as a garage. At one time, someone had cut through that wall and put a garage door in it. You're looking at the picture right now.
Right.
You see that sewer. There's no way in the 1890s that a building's built with a sewer and water unless it's used as a living structure. Okay, if you look at the aerial view, if you'd like to, can we put that aerial view back up?
Mr. Bing, we're getting it up for you, sir.
Thank you. In 2019, when I bought this property, okay, if you look to the left, or give me the street view again. I'm sorry. You could, or no, leave that up for 1 second. 68 across the street at 6811, the corner vacant lot on the corner of Ottawa Avenue, Mr. Brancatelli Street, that he's previously said is a park. That's a vacant lot, and the only thing that's done in that lot is a fire pit where neighbors burn illegal fires. Now, if you would get the street view, please. And I know this because I work in the neighborhood and I drive down the street every day. Okay, to the right of the property, you'll see 6802, the multi-use building with the 2 apartments upstairs and the storefronts downstairs. Those storefronts were vacant in 2019. They're still vacant today. If you look back at the house Mr. Brancatelli is referring as a new construction and new remodel at 6813 Polonia, one directly back from that guardrail. That house has been gutted and used for nothing but drug activity since before I bought that property in 2019. Now, 5 years later, it's getting put back together. What it boils down to is this spot zoning that Mr. Brancatelli used to change just this area to multifamily residential use was only to stop this but the worst part is he led myself and Kurt Weaver to believe that he's working with us to develop this property. And that's why I'd like to give Kurt a compliment. Those drawings that Kurt made are as professional as someone building a Chipotle or McDonald's in your neighborhood. If you guys look at blueprints all the time, we did nothing but go up and above to try to satisfy the city and provide a quality redevelopment there for something where there is no redevelopment going on. And the last thing I'd like to say is there hasn't been any multifamily permits pulled in the areas that Mr. Brancatelli changed at that spot zoning in 2020.
Does that conclude your statement, sir?
Well,
you will have an opportunity to rebut after we hear other testimony.
The last thing I'd like to say, and it's not a rebuttal, is Mr. Brancatelli's not going to be happy until he renders my property useless. He just pointed out to say if cars pulling out of a property, that it's a safety hazard. I mean, how far-fetched is this? It's Harvard Avenue. It's a business district. It's always been a business district. Right next door is the empty Gyro George. Right next door is another car lot on the other side of 68th Street. Next to that is Gyro George. Right next to that, I mean, it's all a business district. But what Mr. Brancatelli has tried to do is go through all legal procedures to take this property and value it useless. I understand he may have been upset about an order of a permit. Well, we try to be as compliant and work with them as quickly as we could. And if you want to know why the hole sat there for so long, which should have been a 1-week process, is because the building department, and Mr. Hussein is there, requires before COVID a yellow jacket they refer to as to pull a demolition permit in your city. And you had to provide in that demolition jacket would have been your the sewer permit, the bulkhead that sewer, and your asbestos permit from the EPA to make sure that, you were compliant. At COVID, they stopped using the yellow jacket. And I was kept being told by the city building department that they wouldn't accept my permit because I didn't have this yellow jacket. Only to find out roughly 4 or 5 months later that finally someone told me in the water department that they don't want you pulling this permit. There is no yellow jacket that's used anymore. The building department had me chasing ghosts to try to move on this project. And we can tell by Mr. Brancatelli's demeanor that he's still trying to do that.
Okay. All right. Does that conclude your statement, sir?
Yes, it does. Thank you.
Okay, excellent. Mr. Linder, do you have anything to add
Just
at this point?
look, yes, the 8th district has made a final determination on facts as well as on the zoning issue. No variances are needed right now. And there's really not much to be considering today, despite all the people coming forward trying to stop the process. But keep in mind, stopping the process renders this property valueless, which in turn creates a greater taking issue for the litigation that does continue pending. So it's kind of a devil's choice, if you will. Either follow the 8th district or we have an even better takings argument. Thank you very much.
Thank you, sir. All right. To Mr. Gray or Mr. Bay, the issue of the street traffic, is this a high crash corridor that you know of?
I do not, Madam Chair, this is Xavier Bay. I do not have the information accessible to answer that question right now.
Okay.
High crash corridor. I can't just tell you off of the site visit I did do, there was definitely a lot of traffic, and the outlet of Ottawa goes directly into Harvard Avenue.
Right.
Which can.
So we have a direct we have a T intersection there.
Correct.
And there's a reason there's a guardrail. So that would indicate that there is a higher propensity of accidents in the area, even though it's not necessarily, we don't know if it's officially deemed a high crash corridor. Did you have anything to add, Mr. Gray?
No, I was going to piggyback off of that. Like, it's high volume for sure.
Okay.
Tell by the intersection. I used to live in this area as well, so we see it all 70 or 77 over there off of Harvard, but coming back that way is always traffic.
Okay, all right, that was just a point of information I wanted to know. All right, Mr. Hussein, do you have anything else to add?
No, but we were open during COVID season, and I don't think we we told anybody that they cannot apply online or in paper. And we were taking the paper applications and stuff, so I don't know exactly what he means that we start.
Okay, all right. Yeah, this goes, I'm gonna come to you, but this goes back to, obviously it goes back to pre-COVID. Our room has been redesigned since. I have a very good eye for people, and I do remember Mr. Weaver from this case because our tables were set up across the front here, and I distinctly remember you, sir. So I have a good recollection of this case as we heard it back then. So we'll go to you now for your statement.
Yeah, just to add,
Please state your name first. for the record.
Caitlin Flannery, just
Thank
to add, we deal with a high volume of demolition contractors. We've never had anyone not be able to submit their paper or online applications.
Okay, great. All right. Mr. Bay, do you have anything further to add?
I mean, last thing I would add is just this written statement from our department, which recaps a lot of things you did here today. If
Yep,
you'd like
go
to
ahead, Doug.
read into the record.
Read it for the record.
A statement from the City Planning Commission. From 2019 to 2020, the Cleveland City Planning Commission initiated a three-phase rezoning process along the Harvard Avenue corridor from I-77 to Broadway Avenue in alignment with the most recently adopted citywide comprehensive plan connecting Cleveland 2020. The zoning map change indicated that the parcel in question changed from general retail to multifamily residential to complement the existing context and the community's desired vision. Because the three-phase corridor rezoning was in accordance with the citywide comprehensive plan, City Planning Director stands by the three-phase corridor rezoning as intentional, strategic, and desired by the community.
That concludes the statement.
There's a bit more that goes into just the background of the case, which is basically everything you heard today about the property owner acquiring the property located at 6806 Harvard Avenue in the middle of the rezoning process. He proceeded to demolish a residential structure and garage on the property. However, by the time he filed the proper application to change the use from a residential house to a used car sales lot, the current zoning was already in effect, and the application was reviewed under the zoning in place multifamily residential. The property owner appealed to the Board of Zoning Appeals for use variance, and the board denied his appeal. Property owner appealed to the Court of Common Pleas, which upheld the denial of the Board of Zoning Appeals. Property owner then appealed to the 8th District Court of Appeals. The 8th District decided that the property owner has a vested right to use the property as a used car sales lot, as was permitted under its prior general retail zoning classification based on an application date entry of a permit to building and housing. The 8th District sent the case back to the Board of Zoning Appeals to consider the owner's change of use application based on the previous general retail zoning classification. City's Board of Zoning Appeals is set to hear this case once again today.
Okay.
I guess all that to conclude, the decision is in your hands, as Shannon stated, to agree with the court's findings as this being general retail, or decide to multifamily rezoning takes precedence.
Okay, thank you. Councilwoman.
Thank you. I think those of us, I think we can all see that there is a lot of history to this case and a lot of frustrations and frankly to what fresh eyes might seem as extraneous information related to this particular the decision before BZA today. I want to clarify my position along two lines. The first is what I've heard from the residents, what I know as a resident of Slavic Village, and my position generally as reflecting the voice of the community. And then second is the question of the legal position before you today. It's very clear, and I want to amplify the voice of the community about not desiring a car lot at this location. That is the singular and unified feedback I have gotten from the residents on either side, Columbia, Ottawa, Indiana. That is beyond clear to me, and as I did, of course, send a letter to the community about this presentation today, where I noted that and said I would reflect that here in my comments today. So I do want to share that with you all. But I think you all know, as a Board of Zoning Appeals, that you have a legal standard in front of you today, and so I fully want to say that I understand that you are reflecting a legal question, not necessarily just amplifying community sentiment. With regards to the legal position, you have the question for you about whether this is to be deemed general retail or multifamily residential. It has been remanded from the 8th District Court of Appeals as general retail. I am not going to opine on it, and to my understanding of my discussion with the city planning staff, to the extent there's any deviation from the 8th District Court of Appeals statement, that city planning would be opining on that to the board today. So I will leave it to city planning to make any statements regarding the legal standard.
Since Joy Griggs left the call, I'm worried we don't have a quorum. She's still here.
All right, do we have Joy online?
Madam Chair, it's Xavier. I'm checking the participants panel as we speak.
Okay. Think you're spotting that, Ms. Wilson?
Good. It does, this is Xavier Bay. It does appear that she has left the meeting. I don't see her name in the participants panel any longer.
All right, we need to reach out to her, please.
Madam Chair, for the record, it is being recorded.
Right, it is being recorded via WebEx,
But I
but,
will also call.
yeah, but let's call.
I think we need a transcript just for any future
Absolutely.
appeals that might.
Yeah, yes. This
while
case needs a report.
Yes, now while we're waiting, Madam Chair, I don't have the next question, do you mind?
No, okay. We'll take a very brief, comfort break.
Smoke me to go.
Yeah, since we're waiting to reestablish connection with our court reporter.
We're gonna come back.
Did Ms. Krupa try to contact?
Yeah, she's trying to reestablish her connection. Had a little technical issue apparently. So. Sorry for the delay, folks.
Do we know where she dropped off?
Just some sort of connectivity issue apparently, so we're working to get her back on.
Well, the good news, it's all being audio recorded, right?
Right, it is, but I think under the circumstances, given the pathway that this case has taken, we want to make sure that there's a transcript of it. So.
Agreed, but ultimately she
you
could
know.
transcribe the audio.
Yeah. I would look at Mr. Bay.
For the sake of day, I still do not see Julie on the participants panel.
Ms. Krupa?
We can move forward. I haven't heard any issues with the sound. Usually, the assistant administrator would let us know if there was a sound issue. And
Okay.
She must be fine.
All right, so if all parties involved are in agreement on this, we'll move forward using the recording as the sole documentation at this point. Since we apparently can't reestablish the connection with the court reporter. And I believe you finished your statement, correct?
Yes, and the only thing that I just want to confirm is that whether the law department wants to comment in addition to city planning on the question, on the legal aspect, but again, I'll reiterate that I see my role here as reflecting community sentiment,
Yes.
which is strongly opposed to a car lot use. But given both the complex procedural posture and the separate takings case, I am going to leave the legal opining to both city planning and the law department.
Okay, all right. Remind me, is this your first time with us in person?
I think I've come for one other one before, but I usually either join digitally or submit a letter.
Right, I believe so. So welcome.
Thank you so much.
It's great to have your articulate statement. I really appreciate that. Did you want to say anything, given your history with the case from the law department?
Mary, would you like to define? No, I typically,
Just take your name for us.
Carolyn Downing from the City of Cleveland Law
I'm
Department.
gonna have you step forward just since we're
Okay.
audio only to make sure we
Audio
capture
only,
you
that's
on
right.
mic.
Okay, thank you. Once again, Carolyn Downey from the City of Cleveland Law Department. I handled the first appeal in this matter. I know that we have two attorneys there here, and typically, when there's, typically when there's a matter that's, remanded to the lower court, that's it. We've been talking about this amongst the other attorneys. We're not really sure why they not only reversed and remanded, but they remanded it not to the common pleas court, but to the Board of Zoning Appeals. And that's something that we really don't have any experience with. And in addition, the commentary, which I put there, but what you read was the only guidance that the 8th district gave to us. Oh. Well, you can probably see it here. Council is correct when he says that the 8th district found that there was a vested right to use the property, but it can't end there because the court also wanted this matter to come back before this board. If they had just reversed it, we wouldn't be here. And I also find, and I believe that you believe the same thing, that they really haven't given you a lot of guidance. I don't think but so that's why we had to get comments from the various departments as to what occurred in the past, or to put it into view with what you're asked to do. There really isn't anything else other than the wording that you find in the decision, which I think you all have.
Yes.
Okay. And that really is it. Now, I did provide initially the entire opinion, and I read that over again a few times last week. I don't think the rest of the opinions really gives you any insight to
Okay.
make that decision. So that's all I have to say, but if there's any specific questions, that's why I came up this morning.
Okay.
So I do have a few
Yes.
questions, Madam Chair.
Let me see if our legal person has anything else to add? No? Okay, you're good? All right, great, go ahead.
Okay, so I just want to clarify, that I am reading the opinion in the same way that you might be. So the opinion states that we're to consider this under general retail. Is that fair to say?
Yes, I'm reading it verbatim.
And
Yes.
it says general
And that says general retail zoning classification. And it also says that, looking at their change of use application. And that's why we really needed to have commentary from those people who actually looked at the application initially and any subsequent, notice of non-conformance and things of that nature on there. Again, I repeat, I don't think this is very clear. Okay.
What else, Ms. Wilson?
I guess the next question is about the change of use application. So if we're considering this under general retail as considered or as instructed by the Court of Appeals, where does that leave us? Like, is there any change of use needed at this point if we're to
If you're
consider this
looking at it
general
under the change of, under general retail, no, because a used car lot is permitted by right in general retail. But the issue of the letter of nonconformance came about because that was issued when what Building and Housing considered the official change of use application in March, in 2021. The original application, which he mentioned, the applicant mentioned in 2020, even though it was written in the system as a change of use, it was only for a residential demolition permit under an OVC residential permit application. So the city of Cleveland, when Rick initially reviewed it, or Chuck initially reviewed the original application, it was solely for a demolition. They would have never known it was for a change of use because there was no car plans. There was no site plan for a car lot. That initial application that's on the timeline, it gives you the dates here. So, that was where the confusion I think comes in.
Okay,
But the court reviewed that.
And that was my next question.
Yeah,
Yes.
so that decision has been adjudicated by a higher court. So in my reading of the 8th District's remand order, we are to consider it general retail and make a decision accordingly.
And they can withdraw because they don't need any variances.
That is correct. So there's no decision to be made.
I just have to say, when they come with a new application.
Just state your name, Mr. Hussain.
This Naveed Hussain, construction permit. So when they come and whatever they are being reviewed under, has to be a new application. And it will go through zoning for the proposed new construction that's going to go up there.
Okay.
For the office.
Yes,
Okay,
and,
then that's fair.
we've discussed that here, is that that's a separate issue, it'll be a separate case,
Yes.
correct?
Yes.
But what is before us today is a remand from a higher court that tells us, instructs us what to do. And while they have not provided a lot of additional instructions, they have provided one instruction that's very clear, that we are to consider this case under general retail.
Mr. Madison.
So Madam Chair, I guess this goes back through you to some of my colleagues here or to the legal. This goes back to the conversation we had before. Does it make sense for us to listen to this case until there's a new site plan that's resubmitted that comes back to us for review under the guidelines that are newly established for us to make a decision? I guess I'm still kind of struggling with what our role is today because we can't really make a decision.
Okay, I think Ms. Leonard's gonna respond, and then we'll
I mean, if they want to be judged under general retail, they should, and they don't want, they're here for general retail for the use, because the variances that were originally on the adjudication order under the previous site plan was based on that previous site plan, and then they were taken away because that was the same site plan. They had submitted a revised site plan, right? But if they are not adjudicated under this current application for all the variances that they need, they would be submitting a new building permit application for new construction, right? And so that in itself is going to automatically cause them to become back to you, because when you, under 359.03, when you get rid of anything that is reminiscent of retail, right, or a used car lot, there was never a used car lot here first and foremost. That's why they originally ended up here. But any new application for a retail office building is going to be adjudicated under the zoning as it is today, if they were to say submit the application tomorrow, right? And so that's multifamily. So a retail office is not permitted in multifamily, nor is a parking lot, a standalone parking lot, or a used car lot, that matter. So there's one of two ways they could do this. You could hold on to this, right? Have him revise the site plan. We have to re-adjudicate it, revise the site plan under that, and adjudicate it under that, or come back and go ahead and have them withdraw today. They get their, their occupancy permit will be returned to city planning, to building and housing, to be reviewed under the site plan that they previously submitted that was compliant, and go forward from there to get their occupancy permits for, and their permits to establish use as a car lot.
Madam Chair, I think there is a third option if the board so chooses to approve it today. This is a separate B number. This would give them the use to develop it as a used car lot. So then that B number wouldn't be hanging out there and wouldn't be withdrawn. There would be a decision made related to that building and housing application, that B number. And then when they're ready, they can apply again to construct the new building. And the difference there would be, it would be an expansion of a non-conforming use at that point, as opposed to establishing a new used car lot.
So you would give them the variance under multifamily today to establish use as a.
Well, they would, does that clarify or muddy the waters?
Yes, so
Yeah.
they, the court has held, decided that, they have a vested right under, to use this property as a used car lot under general retail. That is decided.
So there's no variances needed, is what I'm
That
saying.
is
So
correct.
if they would withdraw, there would be no variances, and then a new building permit would come through to construct a retail office for a used car lot. I would understand that they are a used car lot, but there's nothing on the site that demonstrates that this is a used car lot. They haven't made the improvements.
Right.
They haven't put in a parking lot. They haven't put in an office building. So they would be back in front of this board for variances for the office building and the surface lot and the used car lot, essentially, because it rendered, the new site plan renders this site plan pretty much null and void, unless you put this on hold and let them submit their site plan and it's adjudicated under the current B number. Because it's based on the date of application. If we're basing this adjudication based on the date they were vested in 2020 under general retail, then to establish use as a car lot, everything representing that car lot needs to be on that use permit.
Right.
And so since there's not,
And since there's not, they should just either postpone and submit a site plan so we can adjudicate. He can come back for, under general retail, he's a used car lot, plus he has his variance request. If he has variance needs based on the new site plan. That would be the cleanest way to do it.
yeah, that's clear.
Okay, so.
I
Madam Chair?
don't know additional testimony at this point, are we?
Right, so, yeah, we've got to.
Okay, I had a clarifying point on vested interest.
Okay, all right. Do you want to hear it?
I mean, we're discussing the legal matters at this point. We're not discussing factual testimony.
All right.
It is a big.
It's up to the chair.
Okay, briefly.
Okay, briefly, yeah, I mean, my experience before when we would do zoning changes, and we talk about vested rights or vested interests, is for existing uses. When we would go and change, and this comes up common as a council person, that when we would make recommendations to change use, those existing uses are grandfathered. Those are the ones that have a vested right, vested interest, the use that's there. And as was stated earlier, this was a residential property when the zoning change was made. So the concern I have is, as moving forward, legally, what happens every time the city goes out and publicly starts to look at changing uses or changing the zoning overlays. And the uses that are currently being used, they go and apply for a permit and say, oh, they apply for, so let's go and apply for a demo permit, which is what occurred here, even though it was well after the demo. That now we're having, as legally, the city has a right to contest the decision of that district. Just like the first case, when they ruled in favor of the city, the defendant filed an appeal. The city has a right to appeal that decision as well, which this body can recognize that right to appeal and allow the law department to take another step.
All right, board, any further questions or comments?
Yes, Madam Chair, I guess the question is it up to the appellant to decide if they would like to withdraw the case at this point
Right.
or amend?
Are you all
Yeah,
going to
we're
that?
not withdrawing anything. We're not withdrawing it. The idea of maybe tabling it and coming back with the drawings of the replacement building on the footprint, that's a possibility, but we're not withdrawing this. We've got a vested right. We're going to proceed. And I don't know who the gentleman was who spoke before. I'm guessing it was Mr. Brancatelli, but that isn't true. There's no second bite at this apple as far as the zoning is concerned. This is a general retail zoning. And you know, failure to comply, despite what Mr. Brancatelli may want you to believe, is actually a contempt of court issue. So, yeah, listen, we understand it's created some unusual circumstance. Ms. Downey characterized it correctly. This was an unusual way to get to where we're at. So I understand we're all stumbling with that. And we're willing to work with the city to get where we need to get to, but we are not going to give up. We're not going to take an action that in any way waives our rights.
Okay, so you absolutely do not want to withdraw at this point. That is not an option you want to exercise. Okay.
Madam Chair.
Yes, ma'am.
Could I ask the law department to clarify if we have exhausted the period for a potential appeal from the 8th district? Perhaps that would help clarify.
Go ahead.
We have filed a motion for reconsideration, clarification denied, and to protect our interests, we filed an appeal to the Ohio Supreme Court, and they declined to take jurisdiction. So we've exhausted our appeals on the court level.
Thank you. I think that's helpful.
All right, great. All right. All right. I'm taking any further comments, and then I need you all to decide how you want to go, how you want to proceed.
Ms. Leonard? Yeah, if you table it, can you just get confirmation that they will submit an amended site plan showing the new, and then also because they can be on record whether they went through design review under the previous hearing, before the previous hearing.
Okay.
Because they are in a design review district.
Okay. All right.
It's
So,
totally new construction required.
all right, gentlemen online, did you hear Ms. Leonard's comments of that, about the steps going forward?
And I did. You know, it seems to me that the one option that might make the most sense, and that is you turn around and you rule today that we have the zoning and then we come back with a second application with regards to the building. But I also don't necessarily know what sort of pitfalls that might have in it either. I mean, at this point, I'm viewing this as an open discussion to figure this out.
Okay, all right, fair enough. Have you had direct?
He didn't answer her question.
Okay.
Sir, Ms. Leonard's question was, in your original application, did your client go through the design review process on this property?
I think Kurt would best be able to answer that. I wasn't the attorney the first time. I wasn't the attorney back then. I don't know.
Mr. Weaver, you want to respond?
Madam Chair, I think the short answer is no, we did not. I mean, it was February of 2021 when we submitted, so we were pandemic and
Right.
we were not, we attempted to communicate with the CDC and the councilperson, but there was no dialogue happening at that time, so it wasn't possible.
Yeah.
Right,
That
that's where
seems fair.
we were
considering
at the height
what
of
year
that. Yeah, we were at the height of the pandemic at that point.
So Ms.
Okay.
Leonard, they're going to have to go to the planning commission before zoning can be approved if, they decide to just move it under general retail today, right? And so, but any new site plan adjustments are going to have to be, most likely will end you up back here because the zoning today is multi-family.
Right.
So it seems to me they need to make the adjustments, resubmit, because again, there's no question today for us to decide.
Right.
There's no variance for us to grant.
The resubmittal though will make it multifamily. So if he were to, if you say, you can make a statement today saying that we're looking at this under general retail and you don't need any variances based on the site plan today. If you all table it, they can send me a new site plan to be adjudicated and go through the city planning process for the new construction of the building and the parking lot for the use. Come back to you all and get their, then they can just withdraw because they don't need any variances. Because if you're saying today, we're looking at this under general retail, a used car lot is permitted under general retail. And then if their site plan shows that they're gonna need any type of setbacks or anything of that nature that aren't on their site plan, then they would also have their variance resolved because it's based on the building permit application. So if this building permit application is considered general retail by this board and the court, then this is the application that we need them to amend. If they put in a new building permit application after today, we're gonna be looking at it under multifamily because that's the zoning, because there's nothing that exists on this lot as of today that resembles anything
Right.
of a used car.
Right. Understood, Mr. Weaver? Understood, Mr. Weaver?
Yes.
Okay, all right. I think it seems to me you're gonna be working very closely with Ms. Leonard going forward.
Interview.
Yes.
Essentially,
exactly.
we're just giving them a new date.
Exactly.
Yeah, and then instructions for you, Mr. Weaver, to resubmit your new plans to Ms. Kukla, and then it will be adjudicated accordingly.
And Bill, he can upload it to the
Okay.
permit on the permit portal.
So you clear on that?
Yes.
Okay, all right.
And he'll want to work with Kenya for planning commission because it's new construction.
Okay. All right. So, Mr. Linder, are you clear on what's going on here?
If I hear correctly, we're in effect tabling this today while Mr. Weaver works with building and planning to figure out where to place this building and whether we need variances at all.
Right, right. So you've got your city planner at the table, you've got your council person at the table, you've got the building department at the table, and you have Ms. Leonard here from, who is our chief zoning administrator. So, it is going to be, highly necessary, I think, for you to get all your stakeholders together to move forward on this. You have chosen not to withdraw, so we're going to move forward on tabling this pending your resubmission of your materials and your construction documents. And I would urge you to make sure that you have everyone in agreement when you come back to us.
We'll do our best.
Okay, so we prefer that that you make sure that you've worked with the council person, the planning department, the CDC, any community engagement that's necessary at the discretion of council and the CDC, and go through the process with city planning and the necessary departments. Okay.
For clarification.
Yes, ma'am.
I think we've heard a few times that if they resubmit, it moves it over into multifamily, and obviously we know that's not what's happening, but if you could just clarify so I can explain to my residents how we are effectuating a resubmission while maintaining it under general retail.
Okay, that's a question for Ms. Leonard.
Yeah, so the current zoning as of today is the multifamily residential, right? And so we adjudicate applications based on the date that they are submitted to building and housing. So this application, if they were to submit a new application tomorrow, right, they would be adjudicated under the multifamily residential because there's nothing existing on that lot, the lot in question, that resembles a used car lot at all. They are not grandfathered in, if you will, as a used car lot, right? Under 359, chapter 359. And so if they, as of today, we are being told under the building permit that's before us, under this calendar number 21108, for this address, based on that building number that Ms. Kukla has in her file, we are supposed to review this application under that permit application and that permit application date, which was back in prior to the rezoning change, before the zoning change, under general retail. And so if we are looking at that permit application under that permit application date of general retail, and we haven't closed out that application, the applicant has the ability to amend that application for us to re-adjudicate, but still under that same zoning. So not really re-adjudicating, I'm just looking at the amended parts.
So essentially, they will amend their application, they will not resubmit their
No,
application.
no new submission.
Right.
And that's why I was telling them to just table it, because if they were to close it out today and he resubmits tomorrow,
Then it's a
then
good
then he's back under multifamily and there's,
Right, that's what I wanted to understand.
okay.
We've used the same language in overlapping ways, and I'll make sure that when I
Yep.
explain to residents, it's meant to the existing B number, the existing application, and will be reviewed under general retail.
And I think that's an excellent, good catch on your part.
Yeah.
And excellent way for you to make sure that your community members are clear
Thank you.
on the path forward.
And that's only because of the demolition of their milk building.
Had that not happened, we would not be even have anything to
You
amend.
could make a decision today.
We could have made a decision today. And that's the only difference that I think the eighth district did not consider, because they probably
Correct.
did not. It was not in the record.
Yes.
That
Right.
there's been a change to the property in this whole procedural process.
Yeah.
Madam Chair, I do think we probably should ask the appellant how much time they need.
That was gonna be my next question, because there's a number of moving parts. So to Mr. Sullivan, and your project team, you have a little bit of work ahead of you. So I'm anticipating you're going to need into the new year. But
Agreed.
what are you anticipating, is gonna be your timeline? Given the fact you need to draw plans, go through planning, work with your city planner, your council, your CDC, and probably have a community engagement meeting.
Let me put this on mute for a second. We probably need to chat for a second.
Okay. Do you need to be part of that? Like, do you need to step to the hall or text with anyone or?
No, Madam Chair, thank you. No, I think really it's gonna fall to us working with the councilwoman and the CDC and any meetings or public forums that they may want us to participate in and how that gets
Yeah.
staged
Okay.
and notified of.
Yeah,
I'm thinking you're gonna need at least 90 days.
Oh, and I think in part because of how my office structures the holidays and because the key person at Slavic Village Development who would have been working on this, we've had turnover in that position, it's now vacant. I would actually ask for a little bit longer, I think.
120 or more or longer?
I would say 120.
120, okay, we'll see what they come back with.
I'll need someone to be online at Slavic Village Development.
Did you not have a director appointed or?
We have an executive director, but if you recall from her many years of service, Marilyn Mashinsky was the business person who
Yes,
managed a lot.
yes.
She left a couple of months ago, and then their newly appointed person just left last week. And so now it's been twice vacant, and they're gonna have to go through a hiring process.
Okay, all right. And is it Julie, who's the new director?
No, Shauna Sanders.
Shauna Sanders. Okay,
Yes.
all right. I don't know her. So, all right, great. Are you looking, Ms. Cooper, are you looking forward to dates about, we'll see what the appellant says, but we're about 120 days out.
And that's a lot.
That's a really long
We don't mandate community meetings to the zoning.
No, we don't, but we just want to allow time.
Yeah, and I mean, just think about it, we'll have the National League of Cities conference next week, then it's Thanksgiving the week after that, then my office, the way we structure our holiday time, we're basically running skeleton crew through December. And so we won't even be able to have the community.
I'm being mindful of the fact that we're headed into the holidays and I want to make sure we have a full board to hear this
I
case.
think we should let the applicant.
Yeah,
say.
we're gonna have them come back, but.
Madam Chair, that's just for some perspective, that's 4 months, we're looking at.
Right.
What, March?
Yeah, late February, March.
All right, we'll see what they say when they come back on.
Hi, everyone.
Hello, welcome back.
Oh, thank you. Just knowing when his business cycle is, as well as the fact that, hey, if there's gonna, we were thinking realistically 6 months because that's gonna get us to springtime when we, it's gonna be wintertime. Nobody's doing anything in the wintertime here anyhow.
Okay. All right. So that's even longer than we had discussed on our end. So, Ms. Kukla?
So does that put us around end of April, beginning of May?
Yep.
Yes.
My birthday's April 18th, if you want to make the birthday gift for me.
If the appellant's all right, April 18th could work.
All right, to the appellants, are you good with April 18th?
Let's take a quick look. I have a question for this group too, and that is what if my client decides to put this structure inside of the setbacks and not build on the pre-existing footprint, and no variances are truly needed, where do we find ourselves then?
Yeah, if they have a site compliant site plan, they don't need variances.
They can just build
They
it.
would just come back to untable it or.
Yeah.
Right.
Madam Chair, and I apologize, I'm not an attorney, but there is another option. I'm not sure if this is something we can consider. Could we dismiss it and that way we have a document stating something like we dismiss it based on the 8th district's decision? And something in there about noting that the 8th district mentioned, considered that we should, that the vested interest is based on a certain date, could we do something like that?
Again, there's no question for us to decide.
Right.
In a day, unless.
But it'll be a new
But it'll be
BCA
a new
application.
case, and then they will get, but if they withdraw anyway.
All right, building and housing.
They're not withdrawing, they're amending their current
Right.
application. So if their
Got it.
rights would change based on a dismissal.
And Board of Building and Housing you all have a deadline on the applications, right, for them to move through the process, correct? So it's a certain amount of months or a year.
6 months from the resolution that we established.
Okay, so if the resolution hasn't come through.
Right.
Right.
Okay, all right. So I think
So
that rules out that
April
option. Thanks.
April 18th.
Well, that was a Friday, that was a joke, just to say.
You mean we weren't going out for happy hour afterwards? Is that what you're saying here?
Apologize.
Yeah, exactly. I mean.
After this one.
Joking, of course,
Yes.
for the record. Okay, so give us a Monday that is adjacent.
With regards to that April date, that is Easter weekend, can we maybe push it to the very following meeting?
21st or the 28th.
Your preference, gentlemen, 21st or the 28th?
28.
28th, okay. April 28th, 2025. Mark your calendars, folks. Sync it up.
Madam
right.
Chair,
Yes, ma'am.
because I have to report back to the law director, as also Mr. Linder is aware that there's pending there's a companion case, for a takings involving the same property. There's no resolution that's issued now. Can I report to the law director that the board has determined that the, decision of the H district stands, that there is a vested property interest for the district that it was under, not that you have the residential district. What can I report to
Excellent.
the other
Question.
attorneys
Okay.
involved in this?
I think that we have no decision to make here because the Court of Appeals has determined it's classified as general retail, which gives them a right to build as a assault.
Can anything be fashioned in writing, I guess?
Could you make a statement in that regard, that you're reviewing this case as it stands today under the directive of the H district as general retail, and that you're expecting the applicant to amend his application with the full knowledge that the board reviews it as a used car lot under general retail as a permitted use, but we'll leave the case open in case they need some type of area variances.
Okay.
Or something like that, and you all.
You just said it.
You just made the statement.
Hopefully it got recorded.
I think when Miss Leonard completes law school, she's gonna be very well versed. So, yeah, she's well versed right now.
We depend on.
Particularly when it comes to zoning matters. Okay, so does that give you?
Oh, I mean, I knew what the decision was. I didn't know if the board was going to put anything in writing, since we, again.
Ms. Kukla, do you want to take Ms. Leonard's statement and draft something up? Is that something we can do for?
Or do you all want to offer your support essentially for that statement?
All right, let's do this. We'll call a vote in support of Ms. Leonard's statement to be drafted for use for the law department and other purposes. Do we have any objection to that, board?
No objection.
No objection.
No objection.
Okay. Okay, thank you, Ms. Holster.
Yep.
Thank you for chiming in. So we will have Ms. Kukla kindly draft up Ms. Leonard's concise statement as a statement from the board. All right? And that I'm glad you brought that up, because that'll be a nice piece of artifact in the file for future.
Precisely.
Okay? All right. All right, anything else? Gentlemen, thank you for your time.
Thank you.
And we will trust that will work with all the stakeholders necessary involved so that you can move your project to the next phase.
Thank you very much.
Thank you.
Thank you. Thanks, everyone. All right, I assume are you staying for your other case?
Well, it's the one on West 32nd or 23rd, 39. 39. The appellant asked to delay it, I thought.
Okay, the appellant is here.
Oh,
Is here.
I'm sorry.
Somebody is here.
The fence, and you were stuck here this whole time. We should have knocked it out first. I'll very happily stay.
Okay.
It's about your fence, the 6-foot fence, right?
Yeah.
Okay. I have thought you talked to Mr. Peterson.
Yeah, we talked and then the office called me, later after I talked to him.
Oh, gosh. Well, let's figure it out. Come on.
Xavier talked to the CDC on this.
Yeah, I'm sorry. I thought this was.
Yeah. We took that one first because we knew what we were gonna be in for, so. All right. So, Ms. Holzer, we still have Councilwoman Morrow with us, so we're gonna go to 24-177, please.
Sounds good. Our next case is calendar number 24-177. This is at 3851 West 39th Street. Adrume Isaac Yeka, owner, proposes to install a fence in a B1 two-family residential district. The owner appeals for relief from the strict application of the Cleveland codified ordinances as stated in the agenda and the public record, of which there is one.
And with that, I will hand it over to Ms. Wilson for the oath.
Thank you, Ms. Holter. I'll go ahead and swear in all who are present for this case. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth? You'll raise your right hand, reply with I do, state your name, spell your name, and give your address. I'll start with you. Have you speak a little bit louder so that the speaker.
If you speak into the microphone here.
Adromia is a Pietra, and the address is 38 West 39th Street.
Thank you. You can put your hand down. Can you spell your name for us, please?
Adrumnecyeka.
Okay, perfect. Thank you. Councilwoman Rebecca Moore, REBUCCA FAURER. I do. Thank you. Is there anyone online wishing to speak in this matter? All right, we got a hand raised. Looks like Anthony Peterson. Can you please go ahead and swear in? Not hearing anything if you are swearing in at this time.
Can you hear me?
There we go. I can hear you now.
Anthony Peterson, Metro West Community Development Organization. You mentioned address. Do you want our office address, my personal address, or
Your office address. Do the check in.
Sorry, I'm drawing a blank at the moment. I'm sorry.
That's okay. Why don't you spell your name while you're figuring that out?
Address is 3167 Fulton Road, Suite 303, Cleveland, Ohio 44109. And then spelling of my name, ANTHONY, last name Peterson, PETERSON.
All right, thank you so much. Anyone else online wishing to speak in this matter? All right, hearing none, back to you, Madam Chair.
Mr. Bay, I see we have our court reporter connected back with us. Can you make sure that she got the appellant's name?
Yeah, is that something you want to communicate directly, like over audio? I can send her a message right now.
Ms. Griggs, I just wanted to make sure you got the appellant's name. If you can respond either via the chat box or verbally. We have it on the application, right, Liz?
Yes,
So-
yeah,
okay, great, okay,
I just sent her, sorry,
All right.
I just sent her a message as well.
cool. We've got it in writing, so we'll move forward, but I just wanted to make sure. All right, great. Okay. History of the property.
Thank you, Madam Chair. There's been no change in the zoning since 1929. In our record administration office, we found that in 1928, a permit was issued to erect a garage and to enlarge a cellar on the property. And then, Madam Chair, we see that in a more recent history, a permit was issued for residential board up in 2011. And also there was a residential demolition permit that was issued for the property. And also there are no variances on file for this address.
Super. Legal standard, please.
Madam Chair, members of the Board, appellant is requesting an area variance from the fencing requirements of the zoning code. To obtain the area variance, appellant must prove that denying the request will create practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning.
Great, thank you. Okay, sir, go ahead and tell us what you want to do.
Well, there's an empty lot next to the empty lot that I own, which there was a lot of raccoon roundabout going under my porch. Yeah, dog. So the best way for me to prevent them was on my south side, build a solid fence and leave the front 50% as picket style. So I was requesting parents to allow me the south side 20 feet being solely, because by code I'm not supposed to have side 13 feet long to be solid, should be 50% and 4 feet. And 4 out request 4 feet. I saw it because of the raccoon animal issue I've been facing.
Okay. All right. Pretty straightforward. Mr. Bay, what's our situation with sidewalk and driveway as it relates to the fence?
Yes, Madam Chair, this is Xavier Bay from City Planning. On the screen here, you can see the fence is already built. The bottom left photo shows you where the fence is perpendicular to sidewalk. There currently is not a home in the neighboring parcel, but we do, I mean, in a planning perspective, you could foresee infill housing to occur on this neighboring parcel.
Yep.
For that reason, I'll jump to City Planning's recommendation that that you comply with the code to make the portion of the fence 50% open, just to allow pedestrians to view any vehicles. Look, like with foresight, we can see that a house potentially could be built in here, and there potentially could be a driveway installed, basically.
Is there an existing curb cut for that parcel?
There is not. I'm not aware of any existing curb cut.
And is that tree on the tree lawn, it looks like it's sickly. Is it in a condition that it might need to be come down, or just thinking about placement of a potential curb cut going forward?
I can't offer too much commentary about the tree. It definitely does look like it's been chopped up from the power line that's above it, but I could speak to there being a driveway already existent on the parcel. If you go one more parcel to the south, there's already a driveway to the northern side of it. And so typically, city planning wouldn't really want to see a double drive scenario occurring here. We prefer the infill house to have a driveway parallel to the fence, as opposed to the other side where there's already an existing driveway. Does that make sense?
Yeah, makes sense. So that would mean that tree would come out likely.
I could see something like that happening in the future. It's hard for me to speak directly for
Yeah.
sure.
But the applicant does not own that lot.
Right. We're just talking about the potential of infill housing.
Yeah.
And the eventuality of where driveway might go and how it might impact the pedestrian situation. If there's a driveway adjacent to it, then you want to have more capacity for a safety issue. Right.
Yeah, sorry, Madam Chair, I'll just, to conclude my testimony, yeah, I mean, if you form the fence to be more of what you see on the front yard there, like with the picketing and the 50% opacity, we recommend approval for the fence.
Okay.
I don't even think they'd even need a variance if they comply with the code.
Okay. All right. Why don't we tell the appellant what distance he would need to come back off the sidewalk with that 50% opacity? 13. Excuse me. 13.
I mean, you're saying, you're speaking to come set back from the sidewalk?
No, the distance of the fence that you want.
Oh, I see, yes, yeah, about 13 feet. You
Okay.
want to be in line with the house, so in the bottom right photo, you can see the line of the house here. You want to basically come down that same line, everything from the sidewalk to the line of the house.
Okay.
You want
All
to
right.
keep it 50% there.
If you were to do that, sir, then you would not need a variance.
Yeah, that's the reason why, I thought when I was in the building department, they sent me here for variance because of what I first.
Right.
And that other NPR that they own, it's down to it's barely not even well, kind of thing.
Right.
So I was cutting it, so the animals, that's the issue with that.
Right, the animals. Okay.
Yeah, and
Um,
once you leave it, they're going, they destroy, every time you fix your compost well, they come in 2 weeks, and they go destroy it, big, and then,
You have groundhogs.
yeah,
Yeah, I get that.
that's why.
Question to the Madam Chair.
Yeah.
I hear that the animals are the concern as to why you did not have it 50% opaque. So is it your testimony that the animals can get through the fencing if it's 50%?
It's not because the lots the city owns, all at the back there, they are dug, you know, underground. So they move from the neighbor and going to houses, so.
Right.
That's,
Has this been stopped them from doing that so far?
yeah, because the front side is difficult for them to come to the front side. Using the grass area to go, in the house.
Okay.
The pickets are close enough together on the front side, even though it's 50% opacity, but the size of a groundhog is
So
larger than the space in between the pickets.
So they can't get through the pickets, is I guess what I'm asking. Can they get through pickets?
They can in the front, but because of the presence there, it's difficult for them to use the front. They usually come by the side.
Oh, I see.
Because we have a hideout by the tree. There's a pile there, but the city go back to the tree.
Yeah.
Okay, understood. Thank you for the questions. Thank you.
Okay, all right. Anything else? Anybody? Ms.
Um,
Roca, Ms. Holzer, Mr. Manson?
So the appellant is stating that he would like to keep his
Correct.
solid fence.
Correct. For that reason. Okay, we'll go to Mr. Peterson.
Good morning, everyone. Anthony Peterson, Metro West Community Development. This particular case was brought to my attention a few weeks ago by Ward 12 Councilwoman Moore's office. And throughout the several days and weeks of just kind of back and forth exchange, I've come to understand that Mr. Yeka originally had a solid fence in the front that was I believe three feet. Just in my conversation with the zoning administration, he originally had a solid fence in the front, but later on changed it to a picket fence because of in attempts to comply with current land use laws. In terms of the south side of the fence and the appellant's concern about the animals, just from my stance, I know that pests, raccoons, groundhogs, skunks, all those can be an issue, and can potentially cause damage to people's homes. Just speaking about the potential future of infill development, we do have a housing shortage, in our city. We need more units, and a lot adjacent to that could potentially could be a future infill development. And if the driveway was put parallel to the solid portion of the fence, that again could present an issue. I considering the height of the fence, our office is originally I was not for his current the current situation with the fence, but the thing is we just really don't know when infill is going to come to that particular lot or if it's going to happen at all. So just from a I guess, with our current laws, thinking about our current laws and what's currently going on with the law, I don't see an issue with the current fence at the moment. But I mean, since he attempted to comply on the western end of the fence with the 50% opaque, I don't think it would be an issue to have the same level of compliance, for the 13 feet on the southern side of the fence. So, and yeah, that's all I have. So.
Okay, thank you, sir. We'll go to you, ma'am.
Yeah, thank you. And I apologize that we didn't get to talk personally earlier. I first want to compliment you on building this beautiful fence and maintaining the lot. It is a huge ask for a lot of our residents. I frankly see this as a sort of common sense variance that helps you maintain a property that you are trying to maintain. You can tell from these photos that you maintain a very nice home. And it sounds like you're also even working to mow the lot on the other side. Given your efforts already to make it only 50% opaque in the front, I am comfortable with the variance that he seeks for the side, especially given that he's made an effort to keep it low. It looks like 4 feet in the front part of the property. You still have a pretty good line of sight, and I would agree with Mr. Peterson that although I would love to know that infill is coming soon, I cannot promise that, and I think we have a good resident here who it sounds like we can help him with, raccoon and pest problems with a sort of a low value variance that doesn't impact the neighborhood very much. So overall, I would be in support of his request.
Okay, thank you. Mr. Bay, to city planning, we do not have any initiative ongoing currently or in the near future to do infill in this area. Is that correct?
Not that I'm aware of.
Okay, great. All right, what I will say, sir, is I had groundhogs underneath my back porch. She would birth her babies there. I was kind of her doula. So I'm familiar with the animals, and my backyard is a bit of a haven for possums and raccoons and snakes and other things like that. So what I would suggest to you, I'm not entirely sure that the fence is gonna completely take care of the issue. What often works very well is to put stone at the base of the fence, because oftentimes the groundhogs will just burrow underneath. I have a thoroughfare at the back corner of my yard where the wildlife and the stray cats go through, cross my yard, go underneath the other fence in my neighbor's yard, and visit his fish pond. So, so if you do a larger stone across the base of the bottom of the fence, it usually helps with the burrowing issue. Just a tip for you from my personal experience. Okay. And I have some wonderful baby groundhog pictures if you ever want to see them. They're adorable. Not so much when they get bigger. Okay, any other questions or comments, board? Okay, I'll entertain a motion, please.
Madam Chair, based on the testimony that we've heard, I move that we approve calendar number 24-177.
Great, could I have a second? Awesome. Mr. Manson jumped in with the second. All right. Go for the vote.
Sure. Ms. Roca?
Yes.
Ms. Holzer?
Yes.
Mr. Madison?
Yes.
Ms. Wilson?
Yes.
Ms. Bay?
Yes.
Calendar number 24-177 is granted. It'll be ratified next Monday. We'll send you a letter, but you can contact our office next Wednesday for further instruction.
Okay, you're all set, good to go, and you had the stamp of approval by your council person, so great to see you in good sense.
Absolutely, thank you.
Okay. Do you sing, by the way? Do you sing?
A little bit.
Little bit, you have a wonderful voice.
Thank you for the time. I really
All right.
appreciate it.
We're on to calendar number 3, Ms. Holzer.
Our next case is calendar number 24-176. This is at 18517 Glenfield Road. Rebecca Cruz, owner, proposes to install approximately 139 linear feet of 6 foot high wood privacy fence in a 2-family zoning district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there is one. With that, I will hand over to Ms. Wilson for the oath.
Thank you, Ms. Holzer. I'll go ahead and swear in everyone who's present for this case. There's no one in the room. Is there anyone online present for this matter?
Yes, I am, Rebecca Cruz.
Oh, perfect. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth? Please raise your right hand and reply, I do. State your name, spell your name, and give your address.
I do. Rebecca Cruz, Rebeca Cruz, Cruz.
Okay, and give your address. And give your address, please.
Oh, sorry. Is the one listed on this case as well?
Okay.
That is my business address because I live out of the state.
Okay. And is there anyone else online wishing to speak in this matter?
No, only myself.
All right, hearing none, back to you, Madam Chair.
All right, we'll go to history of the property, please.
Thank you, Madam Chair. There's been no change in the zoning since 1929. In our Records Administration Office, we found that in 1974, permits were issued to replace a roof on a residential property. And Madam Chair, in the more recent history, we see that there was a violation notice issued in 1999 for exterior maintenance. There are no variances on file. Oh, I apologize. There's one variance on file in calendar 75-11. This board denied a variance to use garage for distribution and storage. Again, that was in 1975 in calendar 75-11. And that's all that I have. Thank you.
Okay, legal standard, please.
Madam Chair, members of the board, appellant is requesting area variances from the fencing requirements of the zoning code. To obtain area variances, appellant must prove that denying the request will create practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting variances will not be contrary to the purpose and intent of the zoning code.
Awesome. Okay, Ms. Cruz, go ahead and tell us what you want to do as it relates to the variance that you're seeking.
So I would like to appeal to a variance on the fence being just 3 feet all around. So on the easterly side of the property where the other neighbor is, we have had a couple incidents where like the neighbors have parked their car in a parcel, had work on their cars there, had crossed over to our property, and we have like conducted several communications with them to like have them stop that. So the reason that I'm appealing to that variance is because I want to just put like a 6 foot feet between the two parcels, so it will just divide his house or her house because there's is a couple and my property. And then on the northerly side, I'm okay with the standard size fence. It's just I would like just some privacy and security for my property.
Okay. All right, do we have any, are you talking about a 6 foot dog ear panel fence? Is that
So
what you're-
we propose a wood privacy fence on the easterly side, but I'm okay with any material that you suggest. It just like is the height that I'm concerned about, because if we put like a 3 feet fence, everybody can kind of cross throughout, because even on the posterior side of the property, there's also neighbors that cross to my property as well to get access to the main road.
Okay, got it. All right. Mr. Bay, you want to chime in on this and clarify fencing?
Yes, this is Xavier Bay from Cleveland State Planning. We would recommend that the fence height come down from 6 feet in height to about 4 feet in height for the front yard. Specifically, if you can see my cursor coming across the frontage of the property. Then similarly, coming back in about 5 feet into the property to allow for view of sight. You can see on these images a view if you're walking down the street on the sidewalk. It'd be very difficult to see any kind of traffic coming in and out of the parcel whenever the applicant does decide to use this parking lot or driveway.
Okay. Why don't you go to plan view, back to plan view, and very concisely use the pointer and walk the appellant through what you'd like to have where, so she's clear on that, so she can see. We'll see if she's amenable to those changes.
Understood. Thank you, Madam Chair. Again, this is Xavier Bay. Through the chair to the appellant, can you see the cursor currently on the screen?
Yes.
Okay, so this portion of the fence, where the city planning is recommending that this portion of the fence from the sidewalk to the line of the neighboring house be decreased in height from 6 feet to 4 feet, as well as the frontage of the fence. You can still see my cursor coming across the front of the lot to come down in height from 6 feet to 4 feet as well. And that's really to allow the pedestrian experience to not feel like a pedestrian coming down the street is walking in line of like a wall. It's really for safety reasons. Does that make sense through the chair to the appellant?
Okay, Ms. Cruz, is that clear to you? And would you be amenable to making those changes?
So in that portion that you mentioned prior to the neighbor's house being 4 feet, what about the rest of the fence? Can that be the proposed 6 feet or no?
This is Xavier Bay again from city planning. Yes, through the chair, we don't have an issue with the remainder of the fence being 6 feet high.
How's that, Ms. Cruz?
And the material can still be wood?
We're good with a dog ear? Okay, we're good with 100% privacy, dog ear, wooden fence, if that is your choice.
Okay, I'm okay with that change.
Okay.
Madam
great.
Chair,
Yes.
there is an issue with solid fencing in the front yard. I apologize, I was just speaking with the zoning administrator.
Okay.
Not sure if she stated that it would be open, it needs to be 50% open.
Right, okay.
Yeah, it will be like that. I think like May Fence did a new proposal of the planning, and I think in the front we wanted to keep the standard. We just wanted the side part of
Okay,
reasons
all
that I
right.
mentioned before.
All right, so, yeah, so apparently that wasn't clear in the explanation. So
Okay.
as long as if your intent is to do the front and that portion of the side yard that goes back to what would be parallel or perpendicular to your neighbor's front yard, if that is 50% opacity and at that 4 foot height, then the rest can be 6 foot. All right, are you clear on that?
Yeah, the two little box portion prior to the neighbor house has to be 50% for visibility.
Right, right.
Okay.
Are you good on it?
Can I clarify?
Yes.
So,
Miss Leonard wants to just review the plan for a sec.
so on the site plan here, it says, neighbor's house. There's a neighbor's garage at this location, but it's not a neighbor's house. So I'm just wondering if the applicant, if you go to the images.
The garage is like, if you look at my property, is more on the side. Okay, so that part is where just a main entrance with like stairs, and then if you kind of continue on to the right side of their property, that's where their garage is.
Right, is your property the brick building or the blue building?
No, the brick.
The brick is your house?
Yes. What is a building?
Is your house or your building?
It's a building where I use like as a little office because that's why I have my little mailbox in there. But nobody lives there currently.
So no one resides there.
No, but like I keep storage there of my equipment because I rent houses. So there's a lot of equipment in that property that I wish to keep, safe. That's why I wanted to like maintain or reduce the cross into my property.
Got it. Okay, hang on 1 second.
The applicant should probably establish use for storage of materials in that, because then we would look at this as a commercial fence, not a residential.
Okay.
And before we move
There's a lot of
forward, the
information here,
tree,
sorry.
I don't think we've addressed, is the tree on your neighbor's yard? And there's no intent for that tree to come down for this fence?
So that tree is actually like in my property. So in the picture you can see that I did a survey of the property. So the fence, the proposed fence, will use the tree as part of the fence. I don't know if you're getting the picture I'm trying to draw. So it will.
No, I understand that.
Okay.
Yeah.
Okay, just wanted to just clarify that the tree wasn't coming down.
Yeah.
No.
We're kind of fond of trees, so we want to make sure it stays there.
I have
So-
No, so yeah, I like it too. It gives a good shade.
Okay, all right. Ms. Leonard has a recommendation. Ms. Leonard is our chief zoning administrator. So she's gonna make a statement to you.
So my recommendation would be that the applicant maybe steps with either tables this, asks you guys to postpone, let her work with Xavier and our other zoning planners to make sure that A, she's got the proper application in, and B, that the site plan matches what's actually on site, because
Yep.
this is a little bit misleading.
Yeah.
And I think it would have been adjudicated a little bit differently with all that
Totally
information.
agree. Totally agree. All right, Ms. Cruz, what we're gonna do, because since this isn't a residence where someone is, living there ongoing, it sort of changes your use a little bit. So what we're gonna do is we're going to, Mr. Bay, who's our city planner, is going to send you his contact information in the chat. We're gonna have you work with him to make sure that we've got everything squared away for you. In terms of your use permits and the fencing, because it sort of makes a little bit of a difference as to how we adjudicate this. Because this isn't just a standard residence. And we want to make sure that you're completely compliant with what needs to happen. So we're just gonna put you in his hands so he can guide you through the process. We're gonna do a brief postponement on this. How much time do you need? Xavier?
It shouldn't be too long. It's probably 14.
Couple weeks?
Yeah.
Okay. All right, Ms. Cruz, we're just gonna have you come back. We're gonna give you a couple weeks to get this all squared away. It may require that you get a new plan drawn up. But you'll have a new BFF and he'll walk you through the process. What do we have?
Okay.
Madam Chair, so the 25th is open.
All right, cool.
You'd like to do that exactly 2 weeks, then the next date is December 2nd, if you want to push it.
All right, do you have availability, Ms. Cruz, for November 25th?
Yeah, that's fine.
All right, great. All right, we're gonna move you to November 25th. And we'll see you back. And in the meantime, you'll work with Mr. Bay and get everything squared away, okay?
Okay, and then the correspondence between him will be through phone or email.
Email. The preferred communication is email.
Okay.
Okay.
And he has my email?
Yes, I can obtain it from the.
Ms. Kukla has it, Mr. Bay will get it from Ms. Kukla, our secretary,
I also put it in the chat.
and he put his contact information in the chat. So just be sure you capture that out of the chat, okay?
Okay.
Do you
Thank
see
you.
that?
Yeah, I have
Super.
his phone number.
All right, awesome. All right. So
Thank you so much.
24-176 is postponed. Thank you, Ms. Cruz. We'll see you back in a couple weeks.
Thank you.
All right. On to 24-178.
Our next case is calendar number 24-178. This is at 1348 West 78th Street. 1348 West 78th LLC owner proposes to erect a 3-story frame, 2-family residence with detached garage in a B3 semi-industry district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, which there is one. Madam Chair, do you want me to read any portion of the section a little bit longer, or it looks like there's a note in it?
I think we've got it. It's
Okay.
in our agenda in the public record, so I think we're good. Thank you, Ms. Holzer.
I was
Tossing it
thinking
to you.
magic words. Okay, we'll go ahead and swear in all who are present for this matter. Yes, we will. Is there anyone present for this calendar number 24-178?
Yeah, Jeff Foster, Pato Architects, 1220
Oh,
West.
perfect. Do you swear or affirm? Oh, I'm sorry. I'm gonna just read this real quick and you can take it away. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth? You raise your right hand, reply with I do, state your name, spell your name, and give your address.
I do. Jeff Foster, last name Foster, address 1220 West 6th Street, Cleveland.
We need for you to speak up just a little bit.
How's that? Does that sound better?
That's much better. Thank you.
Better? Okay.
Perfect. Is there anyone else wishing to speak in this matter?
Yes, I'm Reverend Leah Romanelli de Jesus from St. Luke's Episcopal Church.
All right. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth? You'll raise your
Yes,
right.
I do.
Okay, perfect. And can you give your address, please?
1349 West 78th Street.
Okay, thank you. Anyone else wishing to speak in this matter? All right, hearing none, back to you, Madam Chair.
Great. We'll take history of the property, please.
Sure, Madam Chair, there's been no change in the zoning since 1929. In our Records Administration Office, we found that in 1916, a permit was issued for dwelling alterations. 1923, a permit was issued to erect a garage. 1944, a permit was issued to demolish a 28-foot building on the property. 1962, a permit was issued to erect a chain link fence. And the Madam Chair, in 2004, we see that there was a condemnation notice issued for the address. And then in 2015, there was a certificate of disclosure issued stating that the authorized use of the property is a single family. Again, there was another certificate of disclosure issued in August of 2023 stating authorized use as single family. And that's all that I have. No variances on file there. Thank you.
All right. Super. Legal standard, please.
Madam Chair, members of the Board of Health is requesting a use variance from the requirements of the zoning code. To obtain the use variance, appellant must prove that denying the request will result in an unnecessary hardship particular to the property, such that there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning.
Great. Okay. Mr. Foster, I assume you're going to be the spokesperson.
Yes, ma'am.
All right. Ms. Kukla, we have a letter on file authorizing him.
Yes, I think we do.
Not to you.
I'm looking for the authorization sheet. I am not seeing it actually. Madam
But your
Chair.
hair looks good.
Thank you. I will say this is a townhouse project, not a two-family.
Okay.
But it doesn't change the fact that it's a residence within 200 feet. But Jeff Foster was the project representative through the city planning process.
Okay. All right. So he's established.
But if you need his authorization.
Yes, Madam Chair, if the appellant can send it again, I apologize. I
Okay.
don't see it in here.
Mr. Foster, we were just looking for a letter of authorization for you to act on behalf of the client as their spokesperson. And we have verification that you have been working through city planning, so we know you're established. But just as a point of order, we need you to resend that letter of authorization. And it does need to be notarized. So if you could send that to Ms. Kukla for us, please.
We can do that. And the ownership team is on as well.
Okay, great. That's why he didn't send it. All right, there we go. Cool. All right, go ahead, Mr. Foster. Tell us what you want to do as it relates to the variance you're seeking.
I'm sure it looks like there's some audio issues. He's not muted, but I can't hear his audio for some reason. It is moving his mouth.
Can he hear us? Mr. Foster, we've lost you.
I would recommend leaving the meeting and joining again.
Okay, if you can hear us, Mr. Bay recommends you leave the meeting and rejoin.
Okay, let me try one more time. Can you hear me now?
Ah, yay! Round of
Okay.
applause.
Imagine
All
you
right.
just plugging and unplugging. All right. So the project here is to construct two.
Speak a little louder for us, please. A little closer to the microphone, maybe.
Project here is to construct two townhomes on this project. We've been working with Shannon and her team to work through the townhouse overlay requirements. And we have prepared everything for the conditional use through planning. And we have been working with them also from a design perspective. Since it's only 2 units, it doesn't go to the local design review. We've been working with Nathan and working through what some of their requests have been on the exterior design. So the project, as I'd mentioned, is to construct two 1,700 square foot townhomes. And the anomaly of this property is it is an industrial zoned property. It is the 2 units that we're proposing are consistent with the remainder of the street. There are 3 units to the north on the same side of the street and approximately 4 units on the east side of the street that are also residential in use. And from our understanding, there's also some further residential proposed on the north end of 78. That is what we're proposing to do, so I'll turn it back over to the chair.
Great, thank you. All right, does anyone else, is there anyone else on your project team that wishes to speak on this? We have
I don't
Reverend. Go ahead.
No, I don't believe so, but I believe Reverend DeJesus is on.
Okay, yeah, I was gonna go to Reverend next. Go ahead.
I'm sorry, I'm having trouble with my camera and I'm not able to get it to turn on. Do you need me
It's
to?
okay. We're happy with having audio.
Okay. Do you need me to spell my name?
Yes, please.
Okay, so my first name is Leah, Leah, and I have 2 last names. The first one is Romanelli, Romanelli, and the second last name is DeJesus. That's capital DE, capital JESUS.
Thank you so much, because I think we maybe didn't get that when you were sworn in, but anyway, thank you. Appreciate that. Go ahead, tell us, give us your statement.
Thank you. I wanted to voice a couple of concerns as your nearest neighbor. Directly to the south of your house, we own that garage that's directly to the south of where they want to build. And then we also own the church that's directly across the street. That's the white wooden building as well as the brick building behind it. And the first thing I wanted to note is that it's really important to us to be able to maintain access to the back of our building for maintenance and repairs. And so I showed up partially to see the drawings so I could see how that would work. It does look like we can access most of it, so thank you for taking that into account. My only concern would be between the garage and the back of our building there. And then also I wanted to note that all of our drainage goes into that little triangle of grass that you see just to the south of your driveway. So I wanted to make sure that your builders took that into consideration as they thought through drainage and how that will affect the driveway. I do want to note that it is almost lot line to lot line in terms of grass and space, and I understand that you need to do that in order to be able to build anything on that lot because it's so narrow. But that does affect what the neighborhood looks like, and it's one of the few areas of grass in the neighborhood. I would also finally note, I would want our new neighbors to know, we'd be delighted to have new neighbors, but I do want you to know going into this that we are a mission congregation. And because we have limited parking, we do often have folks coming to the church who park in the street. And we do offer a meal every single Wednesday that about 100 people show up to, and many of them are unhoused. So I want to make sure that whoever's building here knows that there's a lot of foot traffic on this street and that they would be ready to be good neighbors to us just as we are ready to be good neighbors to them. With the understanding that the community meal has been going on more than 50 years. So we would just need to be working with our neighbors to make sure everybody stays happy and on board with that. We also have a mobile pantry that goes twice a month where 225 cars line up down the street, not directly on West 78th, but down Detroit and onto Lake. And so we would just want to make sure that they're also aware of that heavy traffic twice a month.
Great, thank you. Mr. Bay, Mr. Lowe's the planner for this area, correct?
Yes, Madam
And
Chair.
have we had input from the CDC, and it sounds like there has not been a community meeting?
This has gone through, sorry, I
Yeah.
apologize. This particular project has been in the works probably for at least a year to 18 months. So,
Right.
NABO supports this. It went through the city planning process. It
Have we
went
had
through-
consideration with the neighbors' concerns?
in terms of it being housing here?
Yeah.
So this property is currently, when this was adjudicated, when the permit came in, was for semi-industry. It is now in the form-based code district and will
Okay.
be permitted by right. So I should add that information.
All right, but the appellant and his clients are aware of the activity in the adjoining, was that
You
in
can ask
part of
the
any
applicant, you can
discussion?
ask the applicant,
Okay.
whether there was a mission. I mean, they've gone through city planning and worked with the former planner, Adam Davenport.
Okay.
As well as the zoning staff.
Okay.
And they have the understanding that this is, today, when this was adjudicated, was semi-industry, but it is now under the form-based code district, which permits housing by right.
Okay, all right. So, Mr. Foster, you've heard the statement by Reverend DeJesus, and I was just having a conversation there with Ms. Leonard, our chief zoning administrator, because typically in situations like this, we like to see involvement by the CDC and some sort of community engagement. So my concern is that you are in fact aware of the activity that goes on at your neighbor's church and using the street for their activities for community outreach. And that is been part of your considerations in the planning and development of this. So I just want to make sure that, everyone's going to be happy.
St. Luke's is nothing new, and they're pretty well established in the neighborhood, so I would assume that my ownership team is aware of that as well, yes.
Okay, great, super. All right, anything else, Mr. Bay? All right, questions, comments, board?
Only one question is, for Ms. Leonard. Do they have the requisite space behind that garage to allow the adjoining neighbor to do any repairs or maintenance to their garage building?
They meet all the setback requirements for the property.
Okay,
Thank you.
great. We want to be clear on that. Good question, Ms. Roca. All right, anything else, board?
Just one further point of clarification. I heard you say that the zoning permits this as of right.
Yes, it's now in the urban node section of the form-based code, and the northern parcels are considered industrial flex, which also allows residential. But when this application, this is the resounding theme of the day, when the application was submitted, it was semi-industry, and north of the property was general industry. So that kind of gives you an idea of how long this application has been in the permitting and went through various rounds of city planning. And it specifically was around the subdivision of lots. Is this a townhouse? As you can see on the adjudication, it says duplex or a two-family. And then the garage situation, right? And so with the Ohio Building Code, they wanted to make sure that however the lot was subdivided met the building code standards as it relates to the fire code. So all of that's been worked out, and all that's
Good.
left is
Okay.
the 200 feet
All right,
of the original zoning.
okay.
Thank you for clarifying.
That always reassures me. I'm only making sure we've taken the fire code into consideration, so. And did I hear this correctly? These townhouses are gonna be sort of an infill kind of project on other parcels? Is that correct, Mr. Foster?
Well, I mean, this is the project you're looking at. I don't know, I'm not aware of this being done elsewhere.
Okay. Okay, great. All right, anything else, board?
Questions?
All right, super. I'll entertain a motion then.
Madam Chair, based on the testimony we've heard, I move that we approve calendar number 24-178.
Super.
Board Member Roca, second.
Ms. Roca hops in for the second. We'll take a vote, please.
Ms. Madison,
Yes.
Ms. Holzer,
Yes.
Ms. Roca,
Yes.
Ms. Wilson,
Yes.
Ms. Bay.
Yes.
Calendar number 24-178 is granted. It will be ratified next Monday. We will send you a letter, but you can contact us next Wednesday for further instruction.
Okay, super. Thank you, Mr. Foster. Good luck with the project.
Thank you.
Reverend DeJesus, it sounds like everyone's well aware of what you're doing in your community outreach. And so good luck to you on that going forward. And we appreciate you being here with us today.
Thank you so much. Appreciate it.
Thank you. All right, moving on to 24-070.
Our next case is calendar number 24-070. This is at 7413 Lockyer Avenue. Yetta Peak, owner, proposes to use an existing single-family residence as a Type A home daycare for a maximum of 12 children in the B1 two-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are two. This is a rehearing from June 3rd, 2024. A variance was previously granted to establish use as a daycare with hours from 7:30 a.m. to 5 p.m. The appellant is now asking to extend those hours to 24 hours Monday through Friday and only to midnight on Saturday and Sunday. With that, I will hand it over to Ms. Wilson for the oath.
Thank you, Ms. Wilson. I'll go ahead and swear in all who are present for this matter. And it looks like we have the appellant here. I'll start with you. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth? You'll raise your right hand, reply with I do, state your name and spell your name.
Yes, I do. My name is Yetta Peak. It's Yetta. My last name is Peek.
Thank you. And give your address, please.
7413 Lockyer, and that's Cleveland, Ohio, 44103.
All right, thank you so much. Is there anyone else online wishing to speak in this matter?
No.
All right, here is none. Back to you, Madam Chair.
Okay, great. We'll take history of the property, please.
Thank you, Madam Chair. I'm not sure if I should really read much more. We heard the history of the property in June of this year.
Well, Mr. Madison wasn't here, so.
Oh, sure. Then I
We'll
can
bring
read.
him up to speed a little bit.
There's been no change in the zoning for this property. We found that in 1900, a permit was issued to erect a dwelling on this property. There is no other variance besides this one on file and nothing of note in the more recent history. But I would also state that the reason why we're here today is to hold an additional public hearing. We notified the neighbors of the changes that the appellant is requesting. We are just doing this hearing as a formality in a way, just to be sure that there are no other objection or any objection. The resolution, there's no note in the resolution testimony regarding any objectors at the time of the hearing.
Okay, so no correspondence and objection.
No, nothing. Thank you, Madam Chair.
Okay. All right, super. Legal standard?
Madam Chair, members of the Board, appellant is requesting a revision to its area variance from the requirements of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by their land or buildings in the same district, will deprive the appellant of substantial property rights, and the granting variance will not be contrary to the purpose and intent of the zoning code.
Great, thank you very much. Okay, Ms. Peak.
My
So
apologies. The reason why I request another hearing is because I stated my hours of working the daycare, not the actual daycare hours, which I wanted that to be revised. That's why we having this rehearing today.
okay,
So I like to apologize for that. That was my apologies. But it's a 24-hour daycare in which the hours are from 6 to 6 Monday through Fridays and 6 to midnight on Saturdays and Sundays.
okay, 6 to 6 Monday through Friday, and 6 to 12 midnight on Saturday and Sunday.
Correct.
Is that it?
Yes.
Everything else remains the same?
Yes. Everything else remains the same.
Okay, super. Any questions or comments, Board? Pretty straightforward. Okay, I'll take a motion then.
Madam Chair, based on the testimony that we have heard, I am going to move that we approve calendar number 24-070.
Ernest Madison, second.
Sorry. Go ahead.
Second.
Yes. Okay, we'll call the vote, please.
Sure. Ms. Roca?
Yes.
Ms. Holter?
Yes.
Mr. Madison?
Yes.
Ms. Wilson? Yes. Ms. Baker?
Yes.
Calendar number, sorry, I'm on the wrong page.
24-070
is granted. It'll be ratified next Monday. We will send you a letter, but you can contact us next Wednesday for further.
Thank you.
Ms.
Thank you
Speaker,
so
I'll take
much.
care of it. Certainly. Thanks for spending the
Thank
morning.
you. Have a blessed
Good.
one.
You too. Good luck to you.
Thank you. Bye-bye.
Bye-bye. All right, moving on to old business.
It's granted. They're gonna send a letter.
We have 2, 3, 4, and 5 without objection, Board.
No objection.
Ms. Holzer?
I was not here for those 4 cases.
Okay, that's right. You were absent. It feels like you've been gone forever.
Forever.
Forever. All right, Ms. Kukla, you want to tell us what's going on with these other items on here?
Well, Madam Chair, the first one is a typical affirmation, BZA 24-078 at 15009 Puritas Avenue. ASAM LLC was granted variances to expand a convenience store attached to an existing gas station in June. The appellant stated that he is working through some engineering document issues and has been in touch with building and housing, so it's moving along, but slowly.
Okay,
More time.
all right. How much more time do they think they need?
Well, this is typical affirmation, so it would give them six months.
Well, okay, excuse me, I'm so sorry. All right. So, without objection, Board, on the affirmation of 24-078?
No objection.
No objection.
Okay, without objection on that. All right, what's next?
So, Madam Chair, this is a unique case. It's been pending with us for ratification for a couple of weeks. You may remember this case, the appellant was asking, and this is regarding 24-162 and 865 Jefferson Avenue. The appellant is requesting to erect a 4-story frame 2-family residence. There were at least 2, I think it was just 2 conditions that the board wanted to see before ratification. One of them was cut sheet showing the garage door windows that reflect the historic character. And the appellant apparently stated on the record that he had a parking agreement. At this time, he is unable to produce anything in writing, and it seems that it actually may have fallen through. So
that's unfortunate.
I believe it's up to you to, I think the best course would be to rehear it, bring it back, and have the appellant make those statements on the record.
Yeah, I think so.
We're given more of those cases and concerns that people have.
Right, exactly, yeah, because I mean, it looks like a nice thing, it looks like a nice structure, but we had some definite concerns about the garage. So, let's bring them back.
Can we do it on November 25th?
Are they good with that, you think?
I didn't ask them specific dates.
Seems like we've already moved a lot of people to November 25th. It's also the week.
Let's do December 2nd or December 9th.
I feel like we need to, are you guys good? I don't know, everyone's gonna have probably travel plans, so are we good with the 2nd or the 9th?
Either one is fine.
Either one's
Yeah,
fine. How about you?
I'll be here at that meeting. I'm not leaving town until the next.
Okay,
week.
all right, okay. All right, let's go ahead and give them the 2nd,
All right.
and see if we can't get this knocked out for them.
Sounds great. They're back on the agenda.
Okay.
That's all that we have on your old business this morning.
Okay, super. All right, on to November 11th. Okay, any absentees for November 11th?
Madam Chair will be absent from that meeting.
Okay,
Madam Chair, I will be absent as well. That is a holiday.
what holiday is it?
Veterans Day.
Veterans Day. Oh, yeah.
Okay.
Only City Hall works on that.
Yes, and
For
it
us,
is a
one of
working
the
holiday
veterans.
for the rest of us who intend to take their holidays.
I give us a personal day.
I'm sorry?
I said they gave out personal days for Veterans Day.
Floating.
As a former veteran, I take Veterans Day off.
I should too.
Yes, you should.
All right, so,
If not three members, we'll have a forum.
all right, Ms. Holzer, are you good for November 11th?
I believe so, yep.
All right, because we'll be missing 2 people, so we'll need to make quorum. And if you could, be in person, I think that would be great.
Okay, I am.
Assuming that I am not sick, I will be there in person.
Okay, that's fine. Since we're only 3, it's better if we have the board in person. And I'm sorry, what?
November 18th. Since we.
Okay, Ms. Wilson will be gone on the 18th. You have anything upcoming, Ms. Holzer?
Not that I'm aware of.
All right. All right. Plan accordingly. Super. Thank you, everyone. We're adjourned.